Check 1, 2.
Check 3, 4.
Check 1, 2.
Check 3, 4.
Check. Check 1, 2.
Juan's here, so we can go ahead and let's go on the record. Good morning. It's June 7th, Wednesday, and we are back on the record in EA-2023-0017. And Mr. Chandler has taken the stand once again. We were in the middle of his cross-examination. And we were up to Mr. Agathon. Would you like to go ahead, Mr. Agathon?
Thank you, Your Honor. Good morning, Mr. Chandler.
Good morning, sir. How are you?
Great, how are you?
Fantastic.
Could you turn to page 6, please, of your direct testimony?
Yes, sir.
The bullet point beginning at line 7 says that Greenbelt has secured voluntary signed easements on approximately 72% of the existing route across Kansas and Missouri, correct?
Yes, sir.
The 72% is a combined figure for both Kansas and Missouri, right?
Yes, sir.
Isn't it true that for the existing route in Missouri, that figure is less than 54%?
No, sir.
What percent of the easements for the Tiger Connector line has Greenbelt secured?
Less than 5.
On a different subject, based on the last CCN case, that was EA-2023-0017, Greenbelt is obligated to pay landowners for a voluntary easement in an amount equal to 110% of the fair market value of the land, plus an additional amount for any structures on the property. Is that generally correct?
Yes, I believe so.
And your proposal for the Tiger Connector line is to pay 150% of the fair market value of the easement property, but with no payment for structures. Is that correct?
That is correct.
How much money will Greenbelt avoid by eliminating the payment for structures on the Tiger Connector line?
None. In general, we would expect to pay landowners more by offering 150% and no structure payments on the Tiger Connector.
Right, I'm breaking down these into component parts. How much would you save by not paying anything for the structures on the Tiger Connector line?
None. So if you look at, in general, the total amount paid to landowners for the Tiger Connector with 150%, even without structure payments, will be more than they would have received with 110% plus structure payments, given the nature of the monopole payment compensation. Monopole compensation in our easement agreement is significantly less than a lattice tower. So given that, the payment for Tiger Connector landowners will be greater with 150%.
Yeah, you keep saying that, but what I'm trying to get at is how much will you save by not paying for any of the structure supports?
If the 150% is approved, we will not save any money by not paying for structure supports.
Well, how much will you avoid paying? If you had to pay structure supports for the Tiger Connector line at $6,000 per monopole,
So
how much would that amount to?
I think one way to look at this, if you imagine a 10-acre easement, and we assume $10,000 in value per acre for that easement, on the upper end, you would expect to see roughly 3 structures in that easement. So if you paid landowners under the HVDC structures, they would expect to receive, I believe, roughly $128,000. Under the Tiger Connector payment, that would be $150,000. So there's no savings associated with not paying structures.
Well, if you don't pay structures, how much would you have paid were you paying for structures? You're not answering that question.
So I think if you know, we would anticipate, I think the estimated number of structures is in Aaron White's testimony. So I think if you look at that number, it's roughly 176, I believe, or around 180. So if you do $6,000 per structure, you could arrive at the math of what we would pay, but it's not a savings to the project given the 150% proposed payment.
Have you done an analysis of how much you'll have to pay for 150% of the fair market value?
We have not done a project-wide analysis of that number, given that we are early in landowner conversations and don't have set values for each parcel.
So if you don't have a figure for the fair market value, 150% of the fair market value for the easements, and you don't have a figure for what would have been paid for the structures, you can't really tell at this point that every landowner is going to benefit by your new proposal. Some are going to benefit, some won't benefit.
I think if you look at if you take that, calculate the 10-acre example that I provided and size that up or down, it's easy to arrive at the assumption that the vast majority of landowners would benefit.
Okay, so some won't.
I can't say that for certain.
Well, if they were going to have, say, 3 structures on a small piece of property, they would have been better off by getting payment for the structures, would they not?
It's unlikely that a small piece of property would have 3 structures.
Well, 2 structures. I'm just asking, isn't it possible that some landowners are going to fare worse under your proposal? I mean, counsel in his opening statement said that many are going to fare better. I assume that means many or some won't.
For the record, I believe it was quoted back to me earlier in this proceeding that I said vast.
Yeah. Yes, I would agree with counsel that the vast majority, it is possible that a small number may not.
Okay, let's leave it at that. On a different subject, at page 17 of your direct testimony, you discuss other proposed modifications to the conditions imposed by the commission in the last CCN case, correct?
Yes, sir.
And looking at page 18, beginning at line 9, under the conditions imposed in the last CCN case, Greenbelt is not allowed to begin construction of any portion of the line until after it has secured financing for the entire project. Is that generally correct?
Yes, sir.
And Greenbelt's now asking the commission to allow it to begin construction of the first phase of the line, even if it hasn't secured financing for the second phase. Is that generally right?
Yes, sir.
That proposal is generally called phasing.
Yes, sir.
And phase 1 generally consists of the portion of the project in Kansas and the portion in Missouri between the Kansas border and the converter station in eastern Missouri. Is that correct?
Yes, sir, in Monroe County.
Yes. So under Greenbelt's proposal, most of the Missouri portion of the line could be built even if Greenbelt decides for whatever reason not to build the Illinois portion of the line. Is that correct?
Yes, sir.
And the project would then deliver a total of only about 2,500 megawatts instead of the 5,000 megawatts now being proposed by Greenbelt. Is that correct?
Yes, that is the capacity of phase one.
And under that scenario, there'd be no direct interconnection between the Greenbelt project and the PJM market, would there?
Under that scenario, that would be the case.
Are you aware of the commission's finding in the last case at page 44 of the report and order on remand, which stated that the portion of the line which will sell into the PJM markets is what demonstrates the financial viability of the project overall?
I am not particularly familiar with the previous order.
So you're not familiar with that provision?
Not directly, no, sir.
I have just a few questions regarding your SUR rebuttal, page 6 in particular.
I'm there.
In general, you're again speaking there of the need for phasing of the project, correct?
Yes, sir.
At line 6 of page 6, you mentioned that Greenbelt did not receive approval for the project from the Illinois Commerce Commission until March of this year, correct?
Yes, sir.
And then at lines 7 to 8, you say that as a result, the land acquisition process significantly trails the process in Kansas and Missouri, correct?
Correct.
Are you aware of any law or regulation which would have prevented Greenbelt from going forward prior to the issuance of the Illinois order in March with all of the preliminary steps which are needed before actual acquisition of easements?
Objection, it calls for a legal conclusion.
He can answer if he is in fact aware.
I am not aware.
Did you start any activity in Illinois prior to the issuance of the Illinois Commerce Commission's order?
Can you be more specific as to what you mean about activity?
Well, direct activity related to the acquisition of easements.
No, sir.
Isn't it true that in Missouri, Greenbelt had already completed its acquisition of some of the easements for the line even before the commission approved the CCN?
Are you speaking of for the main HVDC, for the HVDC route?
Correct. That the Greenbelt had secured easements for that main route even prior to the time that the commission had issued the CCN order.
I do not know.
That's all I have.
Thank you. Is there cross-examination from the ag associations?
Yes, Your Honor. Good morning, Mr. Chandler. Got a few questions for you. In your direct testimony, you talked there about the public meetings that were held for the Tiger Connector line, and I'm looking at I think page 11, page 10, page 11, in that range.
Of which director, Sir Rebuttal?
His direct.
Thank you.
The direct, yeah.
Yes, sir.
And so, did you go to those meetings?
I did.
You went to all of them in person?
Yes.
Who else was there from Greenbelt, if anyone?
We had several representatives from the Greenbelt project development team, our community affairs and public affairs team, and several consultants, particularly associated with the WSP routing.
Okay, was Brad Panasic there? Do you remember?
Yes, I believe he was.
And just for background, who is Brad Panasic?
He is a vice president of transmission business development for Evidentiary.
Okay. And is he the one running this project as far as the actual on the ground work to build it, or is that fair?
He heads the Grain Belt Development Team.
Okay, what is that? What do they do?
So the Grain Belt Project Development Team is essentially responsible for land acquisition, supporting local engagement efforts, and general project coordination.
Okay. And so, and when you say general project coordination, I mean, that is kind of general by its nature. What falls under that heading?
It's a great question. It's, sort of everything from, helping to coordinate and facilitate communication among internal teams, and generally pitching in to make sure that the project is proceeding as planned.
Okay, and I know your direct testimony on the front page, you sort of talk about your role, but I mean, specifically as it relates to this project, is this the only project you're assigned to for Evidentiary, or do you work on other projects right now?
I am entirely focused on Grain Belt.
Okay. And within the, sorry, let me scratch that. Was that true back during these public meetings last year as well?
Yes.
Okay, now at those meetings, did you receive any landowner input?
We did.
Okay, did you incorporate any of those comments into the plan that you've proposed on the final plan going forward?
You're referring to the Tiger Connector route?
Yeah, what we're talking about today. So the Tiger Connector, I'm not talking about most of the back half of phase 1, and I'm not talking about phase 2. I know we talked about all that in 16. I'm talking about Tiger Connector.
Yes, we did.
And I think, just so we're both clear, the question was, did you incorporate some landowner comments? And you said,
Yes, we did incorporate landowner comments into the Tiger Connector route.
okay. And so did any of the, well, before I ask you that, how was the final route decided, if you know? And I'm not talking about from the technical aspect, but I'm saying as between one route versus the other, because there were multiple ones proposed. How was the final one picked?
Yeah, so, I think that the general analysis behind the route selection was described in the routing study submitted by Andrew Burke on behalf of WSP. I think at a high level, the goal of selecting the Tiger Connector route was to minimize impacts to natural and cultural resources in the human environment. And so when we were comparing the different routing options, we selected the one that best accomplished those goals in accordance with the siting guidelines that were laid out, I believe, in section 2.3 of that routing study.
I mean, was landowner input any part of that decision ultimately? So I'm not talking about method, I'm talking specifically about routing right now.
Yes.
So were you more likely to route around a landowner that had a complaint, or how did that work?
No. In general, the landowner comments were incorporated as a way to guide us around certain general features, both on their property and in the landscape of the counties. So, for example, a goal in the Tiger Connector routing was to minimize and avoid impacts to center pivot irrigation. So a number of landowners indicated where center pivots were on their properties. We also analyzed potential center pivot irrigation on properties throughout the Tiger Connector route and sought to avoid those. That's one example.
Okay, so I guess that's what I'm trying to figure out, though. I mean, does landowner input ultimately have anything to do with whether you take the line over a given property or not?
So what we did was, at the public meetings, we at that point, we had a network of segments that were illustrated to the public. And landowners and the public were given the opportunity to view those segments. They were also given the opportunity to provide comment either via a comment card or providing comments directly on the maps that were laid out at those public meetings. And the public input was incorporated in the selection of in the narrowing down of the potential routes associated with the project. And then from there, we identified, I believe, 3 potential routes, and the final route was selected as the best of those options.
Okay. I guess what I'm asking, I mean, because there's a lot of comments in the stack, obviously.
Sure.
And some of them, I don't think I'm overstating it. I mean, they're in the spirit of just, we don't want you, don't come near us. I mean, does that, I think, maybe the one I just picked at random and just looked at was close to that. I mean, does that factor into your determination as to whether you go over that property or not? Does a comment like that make a difference?
So ultimately, we want to take landowner input into account in the routing process, but at the same time, we can't make a decision that is going to make things markedly worse for other landowners. We have to look at the best overall route. And if you look at the route that was selected, that route crosses, I believe, the fewest total number of parcels, impacts the fewest number of small landowners, doesn't impact center pivot irrigation, crosses the fewest number of streams, has the most property boundary in parallel, which allows us to avoid impacting those center pivots and so when you look at, we are looking at the holistic ability of that route to minimize the impacts that we set out to minimize.
So is there a concerted effort to hit the fewest landowners as possible?
Not necessarily.
Okay, and I think I heard you say that it would impact the fewest small landowners. I mean, is there a concerted effort to hit large landholders harder than small landholders?
I think in general, when you look at smaller properties, they are more likely to have homes on them, and it becomes more difficult for us to route farther from those homes. Again, if you look at Route B that was chosen in the routing study, it is the fewest homes. I think there's only one home within 500 feet of one identified home within 500 feet of center line. And so if you look at this, again, going back to the small parcels, they're more likely to have homes, and we strive to keep the line within a reasonable distance, or not back up within. It's preferable generally to have the line farther from a home.
Well, under Missouri law, you have to pay more if you're within 300 feet of a home, correct? If you know.
I am not familiar with that part of Missouri law.
Okay, are you familiar with any of our taking statutes? And just let me clarify before you answer that. I don't want you to, the next thing you tell me, say my lawyer told me, because I'm not trying to get in the middle of your attorney-client privilege. But just as to the general question, regardless of the source, I'm not asking about the source, are you familiar with our taking statutes?
I am not familiar with the text, not generally familiar with the text of taking statutes.
Okay. Is there anybody on the team other than a lawyer? Because I don't want to know what they've told you. Is there anybody on your team other than an attorney that is? I mean, let's say within Brad Panazic's purview that he's managing, is there anybody on that team that knows Missouri's taking statutes?
I mean, I think that, yes, and again, that we are involved in those processes, but we are not attorneys.
Okay. similarly, do you know if there has been any concerted effort to either cross or avoid property that has more than 50 years of ownership within a family?
I am not aware.
You don't know if that was part of the decision either way?
For the Tiger Connector route?
Yeah, for the routing on Tiger Connector, sorry, just to be specific, yes.
That was not a part of the decision-making.
You're certain that's never been part of the decision-making?
I believe so.
To your knowledge, do you know whether well, let me back up, because you may not be aware. Do you know whether or not the company, and that now I'm talking about anywhere along the Phase 1 line, so going all the way back to the Missouri-Kansas line, do you know if the company has sued any landowners to obtain easements yet?
Yes, there are a number of condemnation cases that have been filed.
Okay. Do you know if any of those were filed as far as their timing to avoid the imminent tolling of a 50-year ownership time for a given plot?
No, I do not know.
Okay. And just so I'm clear on that, then, you don't know of any other than a conversation with an attorney for the company, do you know of any conversation ever within the company that gave the directive to move ahead with a suit so the 50-year timing would not run on a given parcel? Has that ever happened to your knowledge?
Not to my knowledge.
Are you certain that it hasn't happened? I understand always when I'm not asking you to prove a negative, but just has somebody represented to you, no, we would never do that, or has that just not been a topic of discussion?
That has not been a topic of discussion that I've had.
Same question then, as far as condemning within 300 feet of a residence. Do you know if a decision has ever been made, other than from a conversation with an attorney, just a decision inside, has been made to pursue litigation where that decision was affected by the question of proximity of the line to a residence?
Not to my knowledge.
And specifically what I'm thinking of here, for example, is, have you ever heard that they said, hey, we got to hurry up and sue because they're about to build a house, then we'll have to pay them more? Anything like that ever been within the company, not from your attorneys, but within the company?
Not to my knowledge.
Has there ever been any discussion tactically within your team that looking forward, that would be a tactical consideration of when and how to litigate against landowners?
Not to my knowledge.
Is there anybody else in your team who would know or who would be involved in decisions like that you could identify?
I'm going to object. I think that the witness has stated that he's not aware of any conversations ever happening. And so there's
I can rephrase the question, and you may still object to the rephrase, but I can try. So, if a decision like that was being made within your team, what person would make that decision?
In terms of who decides when to file a condemnation case?
so I'm not trying to be difficult, but you said that decision. I think that the question is unclear and vague. So which decision are you referring to?
Okay, fair enough. Let's just walk through the ladder here. As a broad principle, who makes the decision on when you will stop negotiating and file a condemnation suit against a landowner?
Yeah, I mean, I think that's typically a collective decision, and the decision to file a condemnation case typically occurs when either a landowner has stated that they have no interest in negotiating with Grain Belt, or we have not been able to file them, or when the negotiations are at an impasse.
You said when you have not been able to file them.
Excuse me, find them.
Thank you. That's what I thought you meant. I just want to make sure I wasn't missing out on something here. Okay. So you mean when you literally can't find, you just don't know where they're at, or you can't get in contact with them? Is that what you mean?
Yes, sir. That can happen where a landowner is we physically can't find them,
Sure.
or if there's, there are ownership questions that take time to track down.
Yeah. Well, and there's a shocking number of unprobated real property parcels in Missouri. It's amazing how many dead people still own property in this state. So that is a plausible possibility. Okay, so then in the context of, well, I think that answers that question. Did any landowners for the Tiger Connector tell you they wanted this line buried on their property?
Yes.
And was that possibility ever considered by the company?
We've generally analyzed the possibility of burying it, and for reasons I think that are maybe outlined in Aaron White's testimony, came to the conclusion that that was not a feasible option for the Tiger Connector route.
Why is it not feasible?
I believe the witness just testified that that's outlined in Aaron White's testimony, so it's outside the scope of this witness's testimony.
I think that's not true. I mean, I understand that may be true, but if this witness knows, I think it's a fair question for him as well. He handles the PR side with landowners, and if he knows, then I think he can answer that.
I'll overrule the objection.
So speaking not as an engineer, but from my layman's understanding, because there are several reasons. I think in general, because Tiger Connectors is a double circuit line, it will serve two separate markets. So to bury two circuits would require, I believe, two separate trenches to be dug in order to avoid safety and engineering considerations with having to service a line that serves two markets. I believe there are some federal regulations around that, but at a high level, we'd have to bury two trenches, and ultimately, I think there might be some thermal considerations with like the heat of the line that might ultimately cause challenges. But at a very high level, burying the line would actually be more disruptive to farmland given those considerations.
That's what the landowners concluded?
No, that's what the engineering team concluded.
Okay, so that's what that's what Grain Belt is telling farmers about their own operation, right?
Objection. That's argumentative and misstates the prior answer.
I don't believe that is what the witness said, that's what they were telling landowners. He said that's what the study concluded.
If I could inquire then, have you ever communicated to landowners that asked to have the line buried that was your conclusion? To your knowledge. And when I say you, I mean Invenergy. I don't just necessarily mean you, but to your knowledge for the company.
I believe there may have been some communication to landowners about the overall challenges associated with burying the line. But I'm not aware of specific conversations with specific landowners about that.
Okay. And you don't know whether any landowner conceded and agreed that would be more disruptive to their operation after being told that, assuming that happened?
No, again, and I'm aware I mentioned landowner impacts, but I think it's important to remember there are whole host of engineering and technical and safety considerations associated with that decision beyond just the landowner impacts. And again, all of that is outlined in the testimony of Aaron White.
And Vinergy, they have buried a 345 kV line in New York, correct?
I don't know.
You don't know? Have you worked on any other projects at Invenergy besides this one?
No, I specifically was hired to work on Grain Belt.
Okay, fair enough. So the bottom line, you would agree with me, Invenergy, or Grain Belt Express, I know there's a separate LLC, so I'm using them interchangeably, but they have no plan to bury any portion of this line on any landowner. Is that correct?
Yes, that's correct.
I noticed, so in your, and I'm looking at page 14 now on your direct. There's a line 9 there. It says, please describe the compensation package that Grain Belt Express will use in its negotiation with the landowners along the Tiger Connector. You see where I'm at?
I do.
Okay. And you set out in 11, 12, 13 that there's 150% fair market fee value payment with 20% up front. And then in 13, 14, and 15, you talk about the balance being either paid as a lump sum or as an annual payment. I'm familiar, obviously the lump sum's easy. I mean, whatever the number is, that's what gets paid at construction, correct? Or at commencement of construction. And I'm sorry you're nodding, but for the record,
sorry.
it's okay. We all do that. Is that right?
That is correct.
Okay. My question is about the annual payment for as long as the easement remains in effect. So what is that and how much is that?
So the annual payment on signing, all landowners receive that 20% initial payment,
Right.
irregardless.
Right.
The annual payment begins with 5% of that balance payment and is escalated by 2% annually per year thereafter.
Okay, so let's just take $100,000 for a nice round number. So make sure I understand the math. $100,000, you get 20 grand up front. And if you took a lump sum, you get 80 grand at commencement of construction, correct? I think I'm doing the math right.
Sure.
And I will tell you, one of the reasons I have to do this is because I can't do math, but that's why I got to choose round numbers. So at 100,000, but if you're going to take your annual payment, then you'd get obviously you'd still take $20,000 up front, right? I mean, a landowner would get that either way.
Yes.
And then at commencement of construction in year one, they'd be paid $5,000. That's 5% of 100,000. That's the number I'm asking about.
Yeah. Without having the easement form or an exhibit showing the payment in front of me, I cannot remember whether it's 5% of 100,000 or 5% of the 80,000.
Okay, it's one of those two numbers.
Yes.
Was that, because I don't know that and I might be wrong, I don't think I ever saw that sheet in any of your schedule exhibits. I saw the easement form itself, but not the underlying contractual document, or is it tied into the easement form? And I missed it.
Let me dig through.
Yeah, and I'm sorry, but help you here, but I didn't see it.
To speed up the process, the easement form is Schedule KC4,
Right, and I've
which
got
is
it.
tab 9 in the witnesses binder.
Tab 9, okay.
Not in your binder, but in the witnesses binder.
I'm tracking. I got you.
I found it.
Okay. And that is in that KC form, KC4 schedule that was filed?
Yeah, so the payment terms are in a separate schedule is it schedule, or an exhibit,
Exhibit, okay?
an exhibit within the easement, and those are typically not recorded and private to landowners.
And that, even a form of that exhibit or the various potential exhibits was not attached to your exhibit for this proceeding, is that fair?
That seems to be fair.
Okay.
And can I jump in really quick, because that is a question that I had and was wanting to know if a sample of exhibits C and D could be provided? And I'm looking at your counsel for that guidance.
Is this as referenced in, so Schedule KC 4,
Yeah, and we're looking at
paragraph
Two.
2A?
yeah. Well, it's in 2 and 2, well, and 2A. It mentions them in both places.
And Mr. Hayden, could you address your remarks to the court so that the court reporter can get
Yeah,
everything
I'm sorry.
down?
Mr. Schulte, it's in paragraph 2 and 2A there. There's a mention of,
Which, just so I'm clear, which exhibits was the judge requesting?
Exhibits C and D, which are the estimate or easement calculation sheet and the structure estimate and crop compensation calculation. And I realize that those might be private to the landowners, but if there is a sample that could be provided.
I'll have to consult with my client before I can make that,
Okay,
before I can respond, but I will do so
okay,
and get back to you.
thank you. Sorry to interrupt, Ms.
okay, and recognizing we don't have the exhibits attached, the exhibits to the easement attached within this exhibit to the court. The best you can tell us as you sit here right now, I think, as you said, and just tell me if I'm mischaracterizing this, it's either 5% of the overall amount or 5% of the balance. Is that right?
Without having that form in front of me, I would say yes.
Okay. Whatever it is, it'll be what that form says, though, I assume.
Yes.
Okay. Now, I guess the other question then is, and again, I think this is all going to be in that exhibit. Does that annual payment never runs out? Is that right?
That's right.
So if the project lasts 30 years, it'll pay 30 years. If it lasts 90 years, it'll pay 90 years. Is that right?
That's right.
Okay. And I know that's beyond the forecasted life, but just throwing numbers around, whatever that number is, it'll continue to pay, correct?
Yes, sir.
Now, if you're not able to get easements, the company's not able to get easements by negotiation, they are prepared to, I mean, I think you said they already have, but they're prepared to sue landowners under Missouri law to take those easements, correct?
Yes.
When they, if you know, when they litigate under the taking statute to take the easement, are they seeking to take it and still pay these terms? Or are they seeking just to go with the bare terms of the statute?
I object. It's outside the scope of this proceeding and this commission's jurisdiction when we get into the actual process of eminent domain. As the commission has recognized in previous orders, it does not grant eminent domain. Eminent domain is granted by the legislature pursuant to statute, and those statutes provide that the district court will preside over an eminent domain proceeding, and so this is outside the scope of this proceeding.
Would you like to respond?
I would, Your Honor. So, I mean, we already are in a world where they have, the company has attempted to reserve its rights and say, look, House Bill 2005 doesn't apply to us. And House Bill 2005 it amended several different statutes, but one of the statutes it amended was 523.010, which I'll just informally call the taking statute, because that lays out taking's authority. And we've got on the table an idea that would even be part of this order, but as to the fifth tartan factor about the public interest, I think the commission has to know what the back half of the process looks like if there's not a voluntary easement reached. Because I don't want anybody, I don't know what the answer is to what is going to be to this question, and this witness may not know. I don't want anybody to,
Hold on, Mr. Schulte.
sorry, I don't want anybody to walk away, though, thinking that if it's not the case, that when they go to court, they're also going to seek to take the easement but pay 150% in court, if that's not what they're saying they're going to do. And I think it does make a difference to the underlying. I'm not arguing that the PSC can govern eminent domain directly in terms of relative to the circuit court, but I think it's important for the commission to hear that as it makes a decision about the fifth factor of the public interest as to how the company plans to conduct itself, if this witness knows, in those proceedings.
Okay.
Because he had, and the only reason I say that for foundation, the question right before this was, is the company planning to sue landowners to take easements if they can't get them voluntarily? And the answer was yes. And so I think that's where the foundation comes in.
Mr. Schulte, you wanted to make another remark.
Yes. We strongly disagree that this commission is required to determine how the statutes, the eminent domain statutes, apply to this company. That is a matter for the district courts. The statutes apply equally to all similarly situated transmission owners, and every other transmission owner that has come before this commission for a certificate has not been subject to an analysis of landowner compensation process, nor has the commission ever addressed eminent domain proceedings as part of a application for a certificate of convenience and necessity. This commission's role is to view whether the project is necessary and convenient for the public interest within its area of expertise regarding electric utilities. That does not extend to eminent domain policy. And so I strongly disagree with Mr. Hayden's arguments to the contrary.
I would like one more chance to respond if I could, Judge.
I would like to just go ahead and rule. I will overrule the objection. Your objection's noted. The witness can answer if he knows the answer.
I don't know, it's been about 10 minutes ago, so I'll ask again. So I think the substance of my question is, if you know, in the unfortunate circumstance that the company moves ahead and sues a landowner to take property, when the company goes to court, is it planning to seek an order to pay 150% as set out in the, looking at your exhibit here, as set out in that KC4 exhibit? Or is it just going to fall back on the statute and say, well, we'll pay whatever the statute says?
And I'm just going to note an objection to that based on my previous arguments.
Objection so noted and overruled.
I am not in a position to know what I am not, again, not being an attorney, not being the person that files those cases. I am not in a position to state what our plans would be for condemnation.
Okay. And just to be clear then, so you're not making a commitment they would do that or they wouldn't do that, correct?
I don't think I'm in a position to make that commitment.
And that's fair, but yeah, okay. I would like to look at this, the transmission line agreement a little more though, and this is exhibit we've actually just been talking about. And this is a schedule KC4,
Sure.
and this is a public document. Got a couple questions about it. Just 1 second here. So this is the transmission line agreement that the company is sending out through its land agents initially to try to obtain voluntary agreement to an easement, correct?
Correct.
And so far, the company's been using CLS, is that right?
Contract land staff.
Yeah, thank you. And I was about to ask what the abbreviation was. So contract land staff, just for background, I think you'll agree with me, that's a company that, I mean, it's in the business of contacting landowners and they do this for other utilities as well, is that right? Or if you know?
I'm not familiar with their business beyond Grain Belt.
Okay. When they reach out to a landowner, though, do they send them this transmission easement agreement as a proposed agreement to see if they'll sign it?
They typically send out an introductory letter introducing themselves and the project, along with other information pertaining, like a potential compensation calculation, as well as a copy of this easement.
Okay, now do you know if this is the easement the text of this easement is the same as if the company were to sue a landowner, would they seek this exact same easement from the court?
I'm going to object again. The condemnation process is governed by the statutes which are passed by the legislature. Those statutes provide that process is under the purview of the district courts, not this commission.
And Judge, I would respond, nobody is arguing that it's not under the purview of the district courts. But it's still relevant to the fifth Tartan factor as to the public interest. Part of this is because the company has come here and said, look, we're going to acquiesce to the 150% provision in Senate Bill 2005 as part of this proceeding, and that's great. Some of that was at Farm Bureau's request. Be happy to admit to recognize that. But then the underlying question, though, of if they don't get to a voluntary agreement, what sort of easement are they going to seek in court, I think is relevant for the court, for this body, not because of who gets to make that determination. It's obvious the circuit courts make that determination, but because it goes to the question of the public interest as it relates to the request to tie to these conditions. And so I think it is illuminating, could be illuminating, I don't know what the answer is going to be, as to those questions about the text of this easement agreement as offered voluntarily versus whether this is also the text they will seek coercively.
Objection overruled.
If I may respond briefly.
One more time, Mr. Schulte.
Counsel for Farm Bureau's argument for relevance relies entirely on his assumption that the eminent domain process is relevant to the public interest standard under the Tartan factors. That finding has never been made by this commission. In fact, the opposite finding has been made, that this commission does not grant eminent domain or oversee eminent domain.
And I have previously overruled that objection and will do so now.
So the question, I think the substance of the question is, do you know whether the language set out in this transmission line easement agreement that the company is going to send out in an attempt to get a voluntary easement, is that the same language they will seek in an order from the court in a condemnation proceeding?
So I would say that the eminent domain proceedings not being an eminent domain attorney or outside the area of my general expertise, I am not in a position to state what our plans would be under the scenario for the Tiger Connector. I'll say that our hope is to not have to enter into condemnation.
Okay. So then working through this language, I mean, in the second paragraph there, towards the end of the second sentence where, well, let's just read that. I want to read that, the beginning of paragraph 2 to you. It says, landowner does hereby grant and convey unto Grainbelt an exclusive as to the types of facilities defined below, perpetual easement, and it defines the easement as a defined term, to construct, operate, repair, and maintain a transmission line as further described below. Do you see that?
I do.
Do you know if the words operate or repair appear anywhere in Missouri's taking statute as something that a company has the right to take property to do?
Objection, calls for a legal conclusion.
I ask if he knows.
There have been a lot of questions examining this witness who is not an attorney about legal processes and contents of statutes. And they all call for a legal conclusion. He has testified he's not an attorney and is not familiar with the text of statutes.
What was your question again, Mr. Hayden?
Well, it was complicated, Judge, but I'm going to try to, it probably was a compound question, to be fair. I think the question was, does this witness know whether the terms operate or repair are contained anywhere in Missouri's taking statute such that they could be obtained for the company in a takings action?
That is a bit specific and a legal conclusion, so I will sustain the objection.
Well, Judge, I've got a lot more questions like that, so maybe that's where we're headed for all of them. I guess I need to put them on the record, though, just to have a record. And I'm sorry, I'm not trying to be obtrusive. We can fly through it, but if that is the court's ruling, I was going to ask that question about a lot of these. So, would you like me to put them in a blanket fashion and then get a blanket ruling, or?
Just proceed. This witness obviously is familiar with the general process, and that's part of his job is getting this project through. So I expect him to be aware of general principles, but whether or not the company is following a specific legal strategy or an interpretation of the statutes, this witness is not going to be able to answer. So with that, you ask your questions and I'll rule on objections as they come up.
Let me inquire then, just to be certain. Judge DePell has said it doesn't appear that you're going to know specific legal strategies or how to proceed on the statutes. Would you agree with that?
I would agree with that.
Okay. And so is it, to save time here, is it fair to say you're not going to know whether specifically the company is going to seek any of the terms in this agreement as it's set here in the voluntary agreement when they go to court? If they have to go to court. I know it's an if, but assuming that they probably have to do it at least once. And I'm not talking about the substance of an easement. Obviously, that's what the action would be about. But I'm talking about the specific terms contained within this easement.
I do not know.
I do want to ask you specifically about subparagraph C in this, or 2.C in the document. That's going to be on the second page of that scheduled case A4. That's for a telecom easement. Do you see that?
Yes.
Okay, and so that reads, telecommunication easement, the easement may also be used for installation, operation, and maintenance of fiber optic cable and other equipment needed for transmission and communication to or by third parties. Is that correct? Did I read it right?
Yes.
Okay. First of all, do you know, is this intended to be communication to or by third parties for the company's sake in operating the electrical line?
That's my general understanding.
Is it alternatively or also there to be able to sell access for telecom line to a third party?
I don't believe so.
Okay, so you don't think the company has any plan to use that easement and then is to sell access onto third-party telecommunication providers?
I don't believe so. Yeah.
Okay. Well, and this, going back up in the transmission easement, it's kind of a similar question. So 2.b.
Sure.
The last sentence in 2.b, so it's actually at the top of page 2. You see that?
The top of page 2.
Yes, it's the last sentence in kind of the half paragraph at the top of page 2.
Sure.
Yeah. It says the easement may be used for the transmission of electrical energy and for communication purposes, whether existing now or in the future, in order to facilitate the delivery of electrical energy. I mean, that one seems to constrain the communication purposes to electrical energy only, correct?
Sure.
But you don't know then whether or you don't know or you do know whether the telecom easement, you don't, well, let me make sure I'm hearing you right. Your belief today is that the telecom easement is not there to facilitate selling access to the actual physical easement to a third party. Is that correct?
I'm not aware of any specific plans to do so.
Okay. Do you know of any affirmative decision that the company definitely wouldn't do that?
No, I'm not typically involved in those commercial discussions.
Okay. All right, just one moment, Judge. I'm just looking at this exhibit here, seeing what I can move past, given the ruling. Judge, to make a record, I would ask, if you look at paragraph 2.b, the very beginning, there where it says transmission easement, you see that, it's the very bottom of page 1.
Yes.
Okay. It says the easement includes rights to develop, permit, construct, reconstruct, repair, improve, alter, replace, operate, use, and inspect. You see all that, you see that language?
Yes.
Okay. And to finish the phrase is maintain and remove a transmission line.
Yes.
As to the words develop, permit, repair, improve, alter, replace, operate, use, inspect, do you know whether the company intends to seek an easement, if they have to move to condemnation action, to seek an easement there that includes all of those words as part of a coerce or a court condemned easement, I guess?
And I object based on grounds already stated.
Well, I'm shocked that Mr. Schulte is.
And
Judge, we've argued about, I think, the substance of this already, so.
then the ruling stands.
Sorry, so we sustained an objection regarding questions about a statute. So I'm a little confused on whether my objection on that question was
I'm
sustained
sorry.
or overruled.
Your objection was,
The question was whether these terms are going to be used I believe, is whether these terms are going to be used in a condemnation proceeding.
Would the companies seek an easement in a condemnation proceedings that uses those same words? That is the question.
And I will sustain that objection.
Thank you. Okay. Okay, I did have a couple questions about your sir rebuttal testimony. If you could pull that out for me.
I'm there.
Okay, thank you. Give me just one moment. I got to scroll down to what I was looking at.
Could you state the page number?
I will, yeah, when I find it. Starting at page 15. And really more 16. So in your sir rebuttal testimony there on page 16, starting at line 13, you see there with a question posed to you, it says on page 6 of Mr. Hawkins' rebuttal testimony, he disapproves of Grainbelt Express's ability to use eminent domain authority because Grainbelt Express is a, quote, private enterprise. Yes, I'm sorry. Let me start over. Okay. On page 6 of Mr. Hawkins' rebuttal testimony, he disapproves of Grainbelt Express's ability to use eminent domain authority because Grainbelt Express is a, quote, private enterprise and claims, among other things, that, quote, landowners are forced to sell their land, end quote. And how do you respond? You see that question?
I do.
Okay. You responded then at line 17. Your answer starts, to begin, Mr. Hawkins does not describe what he means by private enterprise. If private enterprise means a for-profit entity, then his point is illogical and unfounded because the largest public utilities in the state are for-profit, Evergy and Ameren. You see that?
Yes.
And do you recognize any distinction between Evergy and Ameren and what they do versus what Invenergy is doing in this project?
No.
So, as a starting point, well, let's read the next one. I'll come back around. I think we can cover both these first. Paragraph 20, your answer continued. If, quote, private enterprise means, quote, privately owned, i.e. not publicly traded, then his point is also illogical and unfounded because that circumstance is permitted by Missouri law and the commission has previously issued CCNs to privately owned companies. In any event, the manner in which a company decides to raise equity through private ownership or publicly traded stock is not a basis for determining whether such company qualifies to be a public utility in Missouri. Now, I've stopped reading for the record. Question then is, you would recognize, though, that Ameren is a publicly traded company, correct?
Yes.
Is Evergy publicly traded?
I believe so, but I'm not certain.
Invenergy is not publicly traded, correct?
That is correct.
From what I've seen of public disclosures, the majority owner is, for Invenergy, is a government fund in Quebec. Is that correct? If you know, a government fund in Quebec.
I am not intimately familiar with Invenergy's ownership structure.
Okay. Do you know, because I don't think it was in your testimony where, for you, how many employees Invenergy or Grainbelt as an LLC will maintain in Missouri after construction of this project?
I don't believe any specific plans have been made yet, so I don't know how many employees. will remain in Missouri.
You don't have any ballpark? I mean, it could be one or it could be a million, you don't know?
Yeah, so there will be a number of employees at the converter station site in Monroe County, and then Invenergy Grainbelt will also have a number of either employees or contractors involved in maintenance along the line. It's impossible for me to say what that number is at this point.
Okay.
And Mr. Hayden, I'm going to have to interrupt you there because we're going to have to take a break so that
Sure enough.
Mr. Lehman can be elsewhere and the commission can attend their regularly scheduled meetings. So we will reconvene at 10:30, or in the case that the commission's agenda is still taking place, we will reconvene immediately after it adjourns. So for now, we can go off the record. ahead and go back on the record. So we're back on the record after a more extended break than I had expected. But the commission's agenda has adjourned, and the commissioners will be joining us shortly if they're not already back online. Looks like some of them are already back online. So we were in the middle of, or hopefully toward the end of, Mr. Hayden's cross-examination. And
No
we'll
pressure.
just go ahead and resume where we left off.
And I know about where we left off. If I ask something that's been asked and answered, I apologize, but I think it'll be quick. We were talking about Evergy and Ameren as private entities and relative to Greenbelt.
Sorry, could you refer to where that is in the,
Yeah, we had left off, we were looking at the bottom of page 16 and the top of 17 in your rebuttal. I don't know, I'm sorry, I don't know what tab it is in your notebook, but that's,
I have a table of contents that's helpful. Okay.
okay. All right, so I just want to make sure I understand. You said Mr. Hawkins' testimony is illogical and unfounded because the largest public utilities in the state are for profit. Ameren, at least, though, you admit, I think you said, is publicly traded, correct?
I believe so, yes.
And so, in theory, anybody could buy a share of their stock and then at least have shareholder rights in the company to the extent shareholders have rights, correct?
Correct.
And that is not true of Invenergy, correct?
Correct.
Because, I mean, it's held as a completely private corporation that's not even publicly traded, right?
That's my understanding.
Okay. And as far as being a private enterprise, it also is not Invenergy, I mean, and Greenbelt. I mean, they're not government owned. They're not owned by the public at all in the sense the government owns any part of them, correct?
Yeah, I think I've stated before that I'm not intimately familiar with the ownership structure, but that's my understanding.
Okay. And you also don't have, Invenergy and Greenbelt are not owned in any sort of co-op structure with any state within the U.S., as far as you know. Is that right?
That is right.
Okay. And so would you agree then that there are differences between Invenergy and Ameren and Evergy, on the other hand, as far as their ownership structure and public accountability?
Objection. That last statement about public accountability assumes facts not in evidence and is argumentative.
Judge, I'm looking at his surrebuttal testimony. He's saying that another witness has made statements that are illogical and unfounded and given becauses, and I'm trying to get to the bottom of those becauses through cross-examination in the other direction. And he discusses in there issues about, in two different questions, about the notion of privately owned versus publicly traded, et cetera, those issues, and also the issue about whether or not this is a private development versus something serving the public. So,
That's a good explanation of what the cross-examination has been about, but it doesn't explain the use of the term public accountability.
I don't think it's a confusing term, so I'm not sure what the I guess I don't really understand the legal basis of the objection.
I'll you can, and you can clarify.
I'll try to clarify. Ameren can at least be held accountable by shareholders who own publicly traded shares of Ameren as shareholders, correct?
Objection calls for a legal conclusion.
If he knows.
I believe that does call for a legal conclusion. I'll sustain that.
Okay, when you talk about in your, I'm talking, and now I'm looking at lines 17 through 21 on the bottom of page 16. you say, let's look at line 20. You say if private enterprise means privately owned, i.e. not publicly traded. This point is also illogical and unfounded. You see that?
I do.
Okay. And so I understand the point you're making in your testimony, but publicly traded companies, if you know, can they be held accountable by their shareholders?
Same objection.
Well, I will overrule the general, the objection for the general question. The witness does testify about what companies are for-profit and private enterprise in his surrebuttal.
So I think, so the point that this is trying to make is to the extent that we are also regulated by the Missouri Public Service Commission as a utility in the same way that other utilities are regulated, then yes, I don't believe there's a distinction.
As to the regulation.
As to the regulation, correct?
But there is a difference in corporate governance, correct?
Objection.
If
This
he-
witness has testified that he is not an attorney and he is not a witness to testify about corporate governance.
Judge, if that really is the objection, then I guess I would move to strike lines 20 through 20 on page 16 through line 4 of 17, because I think what the company is representing there is he's not competent to testify to the very things he's testified to here. I'm not saying that, by the way. That's their objection.
Okay, I'm going to again overrule the objection. If you want to make a motion to strike, then set that out separately.
With an overruled motion. I understand, Judge. Okay, so the question was, there is a difference in corporate governance between a publicly traded company and Invenergy, correct? If you know.
Yeah, I am not an expert in corporate governance and can't speak to that. Again, what I think we can speak to is the fact that we are regulated by the Missouri Public Service Commission as a utility, as well as to the fact that as stated in this testimony, the commission has previously issued CCNs to privately owned companies.
Just one moment if I could, Judge. Judge, I think that's all I had for now, obviously subject to recross from questions. Thank you.
Thank you. And Mr. Atkinson, you mentioned to me on the break that you had something you'd like to interject.
Yes, thank you, Judge. I'd like to correct a misstatement that I had made during cross-examination of Mr. Chandler. I represented to him that Counsel for Greenbelt, in his opening statement, Mr. Schulte, said that many landowners would benefit from the compensation package being offered. And in fact, that statement came from their position statement. I believe Mr. Schulte is correct that in his opening statement, he said that the vast majority would benefit from the package.
Okay, thank you for that correction. All right then, is there anything from Mr. Hollander today? Is he, oh. Ms. Stimmy? No questions. Associated Industries?
No questions, Judge. Thank you.
Are there commission questions for Mr. Chandler? Chairman Roop?
No, I'll go ahead and defer to Commissioner Holzman. I know he has a list.
All right.
I do have a rather lengthy list of questions, so I just want to prepare you for that.
No problem.
And some of the questions that I have are probably going to meander into the direction of the previous list of questions, so I understand if you can't answer them. I understand, but I'd like to ask them anyways to try to get better clarity on this.
Yes, sir.
Can you confirm the number of Missouri landowners and the number of parcels involved in Phase 1?
In Phase 1 in Missouri or throughout Phase 1 for the entire project?
Well, the number of landowners in Phase 1 for the project would only be the ones who lived in Missouri.
Okay, I wasn't sure if you were including Kansas as well. Okay. The number of parcels, I believe, is in the realm of 578 for Phase 1 in Missouri. It can be difficult to calculate the number of unique landowners given title questions and things like that. And some landowners own land themselves and some in the name of a business. So we typically talk in parcels.
Okay, and earlier testimony provided that 87% of them were under some form of agreement.
Approximately.
And how many did you say, 578? What was that number?
I believe it's in the around about 578.
Okay, you got 87% under. How many do you anticipate being in Phase 2?
I do not know off the top of my head. I don't know off the top of my head.
Could I just want to make a clarification for the record. I don't want there to be confusion in the record, and I think that if I understood Mr. Holzman's question right, your questions, have all of your questions thus far been limited to Missouri?
Yes.
Okay. So, I think the 87% number, and I'll let the
Yes, sorry. Yeah,
witness verify that, but I think we need to clarify.
So
that-
87%
That's
includes
correct.
all of Phase 1, not just in Missouri.
That's right. For Phase 1 in Missouri, we are in the just north of 70%.
70%.
Yes, sir.
Okay, and then in Phase 2, for just Missouri residents, how many do you anticipate? Is that a knowable number?
It is a knowable number. It's not a number that I know off the top of my head at this moment.
Do you have a percentage of what that number that's not known would be, of what you have currently under agreement?
I believe that number for Phase 2 in Missouri is between 25 and 30%.
Okay. What would happen to the payments related to any voluntarily obtained agreements for Phase 2 if Phase 2 never occurs?
So when we sign a voluntary easement agreement, the landowner is paid 20% upfront. Within 3 years, an extension payment of 10% is due, and the balance payment must be paid within 3 years after that, or the easement expires.
Okay.
The easement does not expire for any easements on which the full balance payment has been made.
And do you know the date of when you would have received your first voluntary easement?
For Missouri,
Yes.
I believe that Invenergy began land outreach in the second half of 2020, I believe, and there were a number of easements acquired by the previous owner of the company prior to that.
Okay, so if 2020 got the first 20% up front, then 2023 would be the next 10%. 3 years, they'd do the next 10%, and then the balance of it would have to be done by 2026, correct?
I believe so.
So if Phase 2 is not initiated by 2026, that 25 to 30% that you currently have voluntary agreement with, what happens if phase two doesn't happen by time, will they receive the balance by 2026 to lock in that lease even if phase two doesn't occur?
Could you rephrase the question or restate it, please?
Okay, so the way I understand the time horizon and the math that we've got here, 25 to 30% of phase two Missourians are already currently under agreement.
Mm-hmm.
You've also stated that it's 20% upfront that they would receive for this voluntary agreement. Then within the first 3 years, they would get an additional 10%.
Right.
And then the balance of that would have to be paid within another 3 years. When that balance is paid, question one is that easement is locked in, right?
Correct.
It's no longer revocable by either side.
That's my understanding.
What if phase two is never constructed?
What would happen to those easements?
What would happen to those easements?
I don't know that I can speak to what the company would or would not do in that
Okay.
scenario.
What would happen if the company were to not receive regulatory approval or for whatever reason decide not to build phase two and you've already dispersed the 20% up front and hit the 10% 3-year addition? What would happen to those funds in the event that phase two is not built?
Yeah, so any funds previously paid to landowners would not be clawed back.
Okay, is that in the
That is in the easement.
easement agreement?
Yes,
that
sir.
funds distributed will not be clawed back?
Yes, I believe so.
Okay. The proposal is seeking to make modifications to landowner compensation for the Tiger Connector AC line, increasing the landowner compensation from 110% to 150% of fair market value, eliminating the structure payments and maintaining the agricultural impact payments. Is that correct? So the Tiger, let me say that again. So the Tiger Connector line will increase the landowner compensation from 110% to 150%, and also eliminate the structure payments and maintain the agriculture impact payments.
That's accurate.
That's accurate. Can you explain if or how any landowners might be worse off in terms of compensation under the proposed compensation modifications as compared to the landowners compensated under the HVDC line agreement?
Yeah, it's, as stated previously, it's unlikely that many, if any, landowners would be worse off. I guess there is a scenario where maybe hypothetically, a landowner has a very small parcel, let's say, less than an acre or two, and a structure would be placed on that property where perhaps they could have been better off with a structure payment, but in general, that's an unlikely scenario, I think, from a design perspective.
So is there any scenario in which a landowner that is on the Tiger line would have benefit in an agreement that was established under the original line?
I think in the scenario that I just mentioned, that's hypothetically possible.
Okay. Now this 20%, 10% balance due at the end of the, 6 years, what if a landowner were opting for an annual payment option? Is it differently structured than that upfront payment? And when would those payments start if they opt for an annual payment?
So sorry, I'm just trying to think to make sure I understand the question, but the annual payment in terms of structure is, in terms of how the annual payment itself is structured, not structures, but in terms of how it is structured, is the same as it is in the standard form easement. It would just be based on the 150% calculation, not the 110. And
Okay.
those start in year one.
In year one of signing the agreement or in year one of
It's
operation of the,
so it's, the first payment, I believe, is paid at start of construction.
at start of
And then
construction?
annually from there, and it's escalated by 2% per year.
And how long do those annual payments go for? Are they in perpetuity of the line?
As long as the line is in operation.
Do they run with the land? So if a landowner sells that parcel, the payment remains in place with the land?
I am not an attorney, but as I understand, the easement does travel with the land.
Okay. When are the agricultural impact payments made? What conditions trigger a payment to landowners? Are those payments available in perpetuity, and if and when the appropriate conditions occur?
So the agricultural impact payment is designed to compensate landowners for observed damages during construction. And the payment is, and so that is designed to include compensation for the easement area as well as anticipated damages as outlined, I believe, by the agricultural inspector that is hired by the project as part of the landowner protocol. Those are paid up front. And it is a one-time payment that is designed, it's a one-time payment set at 300% of estimated impact.
Your direct testimony states that additional payments will be made to compensate landowners for crop damage, crop loss, field repair, damage to drainage tiles, temporary or permanent impacts to center pivot irrigators, or other similar impacts should they occur. My concern is the continued impact on landowners' property post-construction, and how will the company address damage caused by ongoing maintenance?
So the company will negotiate crop damage payments with the landowner on a per incident basis.
Do you have a sense of how frequently an occurrence might be that the company would cause crop damage, and how you would potentially mitigate that?
I can't speak myself on to which like the frequency of maintenance or damages would occur in operation. I would say that in general, the company would endeavor to minimize impact.
Now, you testified earlier that you were at the hearing, the public hearings, when we got testimony on this, correct?
Yes, sir.
Some of the testimony that was presented there, I have interest in terms of what happens after this line has been constructed and you have to have access to it.
Right.
If, let me give you a hypothetical. Let's say that one of your towers requires maintenance. It requires a large vehicle to, get to it, and you've had to drive across a commercially viable field, and you've done that damage. Does the easement give the landowner a clear path to compensation, or is this something that they're going to have to hire an attorney for and go through the legal process to get the company to make amends for the damage?
Sir, if you don't mind, I'm just going to pull the easement form up.
Sure. Is that the K?
If somebody could
Case
provide the
C4.
number, that'd be great. Thank you.
KC-4.
Sorry, can you rephrase the question, please?
What is the process by which a landowner will get a reconciliation payment or recompensation for damage done by the company after the line is in operation?
Yeah, so they would work with a grain belt representative to identify the area of crop damages and determine, and working with the landowner, grain belt will determine what that value is and damages will be paid. And it states in the, it also states in section 3 that landowner will be made whole for any damages or losses that occur as a result of non-routine maintenance or reconstruction as well.
When you were attending the hearings and listening to the landowners' concerns, what would you consider was their primary number one concern? What did you hear as the company that they were most concerned about from that testimony?
I think in general, it's a new project, and so it does represent a change to the landscape, and I do know there were a lot of questions and concerns regarding potential impacts to agricultural operations.
One of those operations is pivot irrigation. We heard that the landowners were concerned that these towers would disrupt pivot irrigation. How were those concerns addressed? The connector route, the Tiger connector route map included green circles to indicate the impacted pivot irrigation systems. Initially, how many potential systems were at risk?
I don't know specifically how many pivot systems were at risk. I know that during, following, following the public hearings, in the routing meetings, a number of revisions were made to the potential route segments to avoid pivot irrigation impacts. And ultimately, the route that was chosen because there are no identified center pivot crossings on that route.
So there are none on the new route.
We believe so, yes.
So you would suggest that you could quantify how many accommodations were made from the initial route to the preferred route?
I can't actually quantify how many were avoided, but I can state that the route, as far as we're aware, avoids center pivot crossings.
Can you describe how the landowners expressed desires to utilize existing right-of-ways, public easements, or to co-locate with other existing transmission lines?
Yeah, and certain landowner comments did express a desire to parallel certain existing linear infrastructure.
Were any modifications to the route made as a result of those requests?
I think a number of specific references were made in the routing study itself. I cannot myself detail specific instances, but I know that a number of revisions to potential routes were made.
Why is it not possible to utilize existing right-of-ways or easements? It would seem that if you were going to follow an existing road or you were going to tie into existing lines that were already there, why isn't the company more aggressive about finding ways to have this route be less impactful?
Yeah, so it is true that in certain instances, paralleling things like existing transmission lines can be seen as opportunities. But at the same time, because many of those lines have been up for a while, there tends to be built infrastructure around them. Many times those existing lines are closer to homes or businesses or buildings, and so it's not always ideal to parallel those areas because of their proximity to other features that we endeavor to avoid.
What about scrub cover, marginal, neglected land rather than cropland or property with structures? Was that a part of the assessment?
I believe so.
Several landowners shared concerns over the potential removal of what we might call intentional trees. Some made mention of avoiding lands that utilized USDA Conservation Reserve Program, the CRP funding, to plant those trees. Others asked that their trees not be disturbed because of premature harvest would devastate their crops. Other landowners asked to avoid siting along their tree line because they have cultivated it for years. What modifications were made to address these direct requests by the landowners?
Yeah, I believe the routing study may outline a number of instances where certain requests were made. In general, one of the reasons for selecting the route that we did was to avoid tree clearing, and it's my understanding that the route that we chose of the ones we evaluated will require the least amount of tree clearing.
Okay. I remember a gentleman who testified at the hearing that on his property, he requested that you move the line some 50 feet, 50 or 100 feet, for whatever reasoning that he had for his property that made more sense. And he was told that that wasn't going to be possible. Do you have an opportunity in place to communicate directly with the landowners on the line through their property if and when something like a simple 50-foot move might make sense and doesn't deter or adversely affect the route of the line?
Yeah, so in the landowner negotiation process, we do begin conversations on micro-siting adjustments to the line, and an important part of making those micro-siting adjustments is where feasible from an engineering and safety standpoint, we will try to acquiesce to landowner requests.
Is that something that's only provided in a voluntary scenario?
I think as stated before, I'm not incredibly familiar with the end stage of the condemnation process, but I do believe that we, in general, want to, if possible, we would do that. But again, I'm not specifically familiar with any particular condemnation adjustments that have been made.
Okay. I tried to ask this question yesterday and was directed to inquire of you instead. Several farmers that utilize organic farming practices raised concerns that they would lose or potentially lose their USDA organic certification if the structure and wires were constructed on or over their land. Are you familiar with what is required to receive that certification and whether the installation of an HVDC line would cause those farmers to lose organic certification?
Yes. For an answer to that question, I would point towards the agricultural impact mitigation protocol.
Page 10, provision 18.
That is correct. So this section of the mitigation protocol details how Grain Belt will work with landowners to minimize impact to organic farm production methods.
Have you identified how many of those landowners might require that mitigation?
To my knowledge, we have not quantified them at this time. The letters, we will send letters to landowners and tenants prior to construction, inquiring about the presence of those farm production methods. I don't believe those letters have been sent yet.
Okay. I want to return to crop compensation for just a second. In paragraph 3, it states that Grainbelt will repair or pay at Grainbelt's option, landowner or its tenants for any damage to improvements, livestock, crops, etc. The term at Grainbelt's option, from a, I know you're not a lawyer, but from a legal perspective, you know, we've all had our fair share of experiences and hassles dealing with warranty claims and product rebates. And when I read the provision at Grainbelt's option, I have to wonder what assurances the landowners have that that provision isn't a, you must sue me to have me compensate you for that. And I want to hear from the company of their interpretation of what at Grainbelt's option means when it comes to these easement agreements.
I'm having a hard time finding that particular line. Could you direct me to that again? Sorry.
Let's see. It's going to be in the KC-4.
Yeah.
Subsection 3. Top of page 3 under crop compensation. Grainbelt will repay or repair at Grainbelt's option, landowner or tenants.
Thank you for that clarification. I was looking too deep in the paragraph. So, again, not being an attorney, my interpretation of that is that it's not Grainbelt's option whether or not to make the landowner whole. It is whether to repair or pay for the damages, not whether any recompense occurs.
And again, this is if it's a voluntary easement, correct?
That is correct.
So I know I know your council doesn't feel like we have the authority to go into the condemnation section of the statute to discuss as a public interest. But I would ask this question: do any of these protections in this easement agreement get transferred to a property that is eminently domained?
Yep. My assumption is yes. I cannot imagine that Grainbelt would want to treat landowners differently in the operations period, whether or not they were condemned or signed voluntary agreements.
As far as the annual payments go, you said it's a 2% escalator each year.
Yes, sir.
Is that in perpetuity for as long as the transmission line is in operation?
Yes, I believe so.
And I know you cannot predict the future, but what do these landowners, what is the company's response to these landowners who are concerned that in the event that your company was to become insolvent and no longer operate this transmission line and these agreements would potentially be forfeited and they have these structures on their property, what is the company's response to that concern?
So in the Missouri Landowner Protocol, which governs certain actions of the company, there is a section 8, about the establishment of a decommissioning fund to handle the activities of dismantling, demolishing, and removing all equipment, facilities, and structures, terminating easements and filing the release of such easements, and securing, maintaining, and disposing of debris with respect to the project facilities, and performing any activities necessary to comply with applicable laws, contractual obligations, and that are otherwise prudent to retire the project facilities. That's kind of an abbreviation, but that is the sense of what that part of the protocol outlines.
And where would the funds come to execute that?
Sorry, what was the question?
Would there be funds to execute that?
Correct. So at the commencement of construction of the project, Grainbelt shall establish a decommissioning fund in an amount reasonably necessary to perform the wind-up activities described.
And who would determine what's reasonable amount?
I don't, we have some kind of static
Yeah.
or something, but I'm
Yeah.
not sure.
Something's happened. Stop. Nope, now it's back.
Yesterday, it was the air conditioning unit. I don't know what it is today.
Well, let me ask another question,
Yeah.
because I'm interested to hear who decides what's reasonable. Do you have a suggestion of what would be reasonable? What that fund would require to have in it to successfully mitigate the construction of this line?
Yeah, so I do not specifically know who determines what amount is reasonable. I would note that in the section describing the decommissioning fund, it does describe that the fund shall be increased as construction of the project progresses, sufficient to cover wind-up activities for project facilities that have been constructed and installed. So, I think you can take that to read that the funding would be sufficient to cover those activities.
Is there any contemplation if the company were to sell this line?
So it's my understanding that all the landowner protocol and the agricultural protocol govern the project irregardless of who owns the entity. So I think that in the event of such an occurrence, these would still govern the project.
Okay, this is my last series of questions. Does the company have a preference in a voluntary lease easement that is either an upfront payment or a perpetuity payment? Do you suggest one or the other to the landowner as one being more beneficial than the other?
No, we do not. That's a personal decision that the landowner makes.
Do you present the math of what they could potentially expect if they chose one or the other?
Whether that math is like specifically presented, the concept of both is explained in depth to the landowner. And generally it's a question of whether the landowner values the upfront payment for whatever reason in terms of having that set amount at the time, or whether they value recurring revenue from the project. And that's where it comes into a personal decision about what's important to the landowners themselves.
If a landowner has made a decision and then have decided that another direction would be in their interest, do they have the ability to refund and change? Is there any provision that allows them to change their mind?
I do not know the answer to that question.
Okay. You say that you've got 87% of phase one under voluntary agreement, 70% of that is in the state of Missouri. That leaves 30% in phase one for you to continue to negotiate with. Do you have a time frame for when you think that 30% would potentially be in voluntary agreement? Or do you have a time frame in which you believe negotiations will cease and then you will start condemnation process.
No, not myself. As stated before, the decision on whether or not to enter into condemnation is really a result of whether a landowner is willing to negotiate or whether negotiations are at an impasse and no longer viable. It's not necessarily a time perspective.
But there is a clock ticking because you have to have anybody who joined voluntarily has 6 years before the balance is paid. And I would think that the overall time horizon on the project probably has some sort of financing clock associated with it as well. So the company must know how long they have to continue voluntary negotiations before it has to switch over.
Yeah, I would just state we're in late stage negotiations with a large group of the remaining 30%, but ultimately we are committed to voluntary negotiations
Do you
where they
have
continue to be productive.
do you have a target or a forecast of what percentage you will land on that are voluntary?
I do not.
Okay. My last question is, we heard from some of the landowners in these hearings that they felt that there was a little bit of, and I'm going to choose my words carefully here to try to reflect their sentiment. There was a little bit of predetermined coercion in the presentation of the lease agreements. I want to give the company an opportunity that you didn't get in the hearing to address rather any of your negotiation tactics were intentional or unintentionally part of any type of, it's already concluded, so you might as well go ahead and sign up because this is going to happen. And if you don't sign up now, then you'll regret it later. Because that's what we heard in the hearing.
Yeah, I would say that's not how Grainbelt Grainbelt land agents communicate to landowners. In general, we understand that there is an impact and potential inconvenience associated with landowners, associated with the project to landowners. But at the same time, the intention of offering 150%, or in the case of the HVDC route, which the 110% plus structure payments, it's my understanding that that is significantly higher than what landowners may receive from another transmission company. So we try to recognize that through a fair compensation package, through the advanced crop damage payment, which is my understanding is generally more generous than what landowners would receive from other transmission companies, and through the things like the option for annual payments. And I think at the end of the day, by being governed by the landowner protocols, by the agricultural impact mitigation protocol, and the code of conduct, Grainbelt is held to, I think, what most would see as a very high standard in terms of landowner outreach and communications. And that's, I'll stop there.
Do you think the commission has the authority to determine what is just and reasonable in that decommissioning fund for the CCN to proceed?
think that is beyond my legal expertise.
All right, thank you, Judge.
Thank you. Mr. Chairman, you had some additional questions?
Thank you, Judge. Yeah, I haven't follow up on a couple of Commissioner Holzman's questions just to clarify. So just to clarify, to make sure I heard you correctly, the 2% increase each year, you said was in perpetuity,
Yes, sir.
and there is no cap.
No, sir.
Okay. Regarding the agriculture impact payments, you stated that was during construction. And then later, you were discussing it about maintenance, and I believe I heard you say it would be the agriculture impact payment would be available for non-routine maintenance. Does that exclude any damages to agriculture on routine maintenance?
It does not.
It does not. So routine maintenance, non-routine maintenance, the agriculture impact is still applicable.
That's right. I would point to, in the crop compensation section, the statement of whether such damage occurs before, during, or after construction, and I would interpret that as crop damages for routine maintenance as well as non-routine maintenance.
Okay. I thought I heard you say non-routine. I just want to make sure there was not an exclusion. Bit of confusion in my mind on the conversation I believe you were having with the counsel from the Agriculture Association. I believe in that conversation, we were talking about the 150% payments of the value. There was 20% up front, and then the balance is then lump sum or annual, and the annual is 5% year one, then 2% each year. But I thought I heard in the conversation with Commissioner Holzman that it was 20% up front when signed, then 10% within 3 years, and then balance paid in another 3 years. So is there a...
Yeah, thank you for the opportunity to clarify that. So there's a 20% upfront payment to landowners. After that, Greenbelt could pay the full 80% balance, but there's also provision for a 10% second payment, which in effect, that 10% payment would be due within 3 years. And that basically extends the easement. And so 3 years after that, we would have to pay the remaining 70%. So that I was probably a little unclear. So Grainbelt could pay the full 80%, or they would pay, and the most likely scenario, to be candid, is probably paying the 10% and then the 70% as the full balance payment.
So there's this. So this would be for those that chose not to do the annuitized, perpetual payment. This is just applying to those that wanted the upfront payment.
Right, and to clarify the exchange earlier, the 5% payment would be, the initial 5% payment would be either of the 70% or 80% if Grainbelt made the full balance payment up front, and then escalated 2% per year from there on out.
Okay, so the 5% comes into play if the landowner has taken the payments in perpetuity as long as the project.
Right.
The 10% within 3 years is for the lump sum option.
So I believe that's for all landowners. So all landowners would receive the 10% as the second payment to essentially extend the lease option, or excuse me, the easement option.
So I'm
And then-
confused where the 5%,
The 5% is the first annual payment that is paid to landowners, and that is 5% of that balance payment. And then from there, that 5% is escalated by 2% every year.
so that runs different numbers in my head. So 20%
Yeah.
upfront, 20% upfront payment. Using the council's $100,000 example. So 20 grand upfront, there you go. Year one, they get another $4,000, which would be 5% of the 80,000 balance, correct?
So what, if we're, I was starting to do math, which is a bad idea for me. Using the $100,000 example, the landowner would receive $20,000 at signing, $10,000 3 years later, and then either $70,000 as a lump sum balance or 5% of $70,000 for their first annual payment.
And that annual payment of $5,000 would increase by 2% each year?
That is correct.
Okay, so the 2% increase is on, in that example, is on the 5,000.
That's, yeah, assuming 7 is 5%, 5,000
Yeah,
is
yeah, so.
5% of, yeah, that's, no, sorry, it would,
If I may, we do still have our little fun rate calculator, I
Oh.
think, up there, if that would help the witness.
there we go.
I also think that those missing attachments to the easement contract may have some of these calculations on it, if I'm correct.
You are
And
correct.
so I think the commission's going to need those.
We do have those. Would you like me to, I was waiting for redirect, but we can enter those now if that's more appropriate.
Did you say you have copies?
I do.
I think that would be a good thing.
And for the record, there are two sets. I just want to, before I give them away, I want to make sure I explain them. There will be two exhibits. Exhibit 24, if I have my numbers right.
Yes.
Exhibit 24 includes Exhibit C, easement calculation sheet, and Exhibit D, structure estimate and advanced crop compensation calculation, in a standard form example for the HVDC landowners. That's Exhibit 24. I want to keep one too. And Exhibit 25 includes Exhibit C, easement calculation sheet, and Exhibit D, advanced crop compensation calculation in a standard form example. For the Tiger Connector landowners, assuming that the 150% fair market value payment structure is approved. That's Exhibit 25.
Okay, thank you. Would there be any, well, you guys haven't seen them yet, but I was going to ask if there'd be any objection to the commission receiving those attachments into evidence. I'm seeing none, so commission will enter those into evidence. And copies are being circulated.
Might go easier now.
As these are being distributed, they're not pre-marked. My apologies. But the easy way to tell the difference is Exhibit 24 has a landowner name, Jane Doe, at the top. And Exhibit 25 has brackets for the landowner name.
Okay, thank you for that clarification. And Mr. Chairman, whenever you've had a chance to look at that and are ready, just go ahead and continue.
Yeah, we'll review this a little more in depth,
And
but I need to.
did the witness receive a copy of that
I
too?
do,
Okay.
thank goodness.
So again, I'm going to go back. I need to understand this conceptually before I can.
Sure.
So in the $100,000 example, the 20% upfront, so there's $20,000 payment. The next payment is 5% that is due in year one, and the 5% is on the remaining balance of the 80,000 that is owed?
So if you are looking at Exhibit C, the easement calculation sheet,
So it's,
And-
I'm sorry, can we pause? We're having a
Oh.
distribution issue.
Yeah, I'm sorry. I jumped the gun there trying to get things going.
Okay, I think we're clear. Thank you.
Thank you.
so I do
I'm sorry.
read that it says 10% of the total easement consideration.
Correct.
In the second payment. So that would be 5% off the 100,000, correct? If we're using the 100,000 initial.
so 10% of total easement consideration would be $10,000.
Okay, yeah, so 10%. So where did this 5% number come up at the end of the first year?
So if you look in line 4 of the schedule for payment of total easement consideration, it specifies 5%. And so that would be 5% in this situation of $100,000, 5% of 70,000, which this calculator tells me is $3,500. And it would be escalated by 2% annually from there.
And so it would be $3,500 for year 2. Then it would be $3,500 plus 2%. The next year is whatever that number was plus 2% and into perpetuity.
Yes, sir.
Okay.
Where's it say?
In your exhibits, these examples, in Exhibit 24, the one with Jane Doe, You have a total easement consideration of $34,958. Is that a representation of the average? Or is that an arbitrary number? And then third question, what is the average that you have been?
So that's an arbitrary number. I would say that that is significantly below average of what we're seeing currently for Tiger Connector counties. I would anticipate cropland, based on what we've observed and what has been communicated in initial outreach to landowners. In general, cropland is north of $10,000 per acre.
Okay. The only other unclear thing I have in my head is, and I think you answered it, but I just need you to repeat your answer. If condemnation proceedings are gone and through with, and the land has been taken via eminent domain, will the 150% of value be applied to that valuation in the, or the larger of the two?
Yeah, I cannot say at this time what the condemnation compensation would look like for Tiger Connector counties.
Judge, that completes all the clarification questions I had. Thank you.
Commissioner Hahn?
Thank you, Judge. Thank you. To go back to the easements briefly, you had stated that 578 landowners are in Phase 1 that are Missouri landowners, and about 366 of those easements have been obtained. Can you say how many of those easements have been voluntarily obtained?
Yeah, so bear in mind that without having the numbers directly in front of me, I believe the number of voluntary easements acquired for Phase 1 is 369 easements. 369 easements voluntarily acquired for Phase 1 in Missouri. I believe without having the numbers directly in front of me.
Can you say how many easements in Missouri have been acquired that have been involuntary?
Yes. We have filed 19 condemnation cases in Missouri. Of those, I believe 6 have been have concluded via negotiated settlement, and I believe 4 have been acquired through the legal process.
Can I ask the gentleman with the camera to turn the light off? Thank you. apologize.
No problem.
I'm sorry. I caught that 19 proceedings have been filed. 6 have concluded by settlement, and 4, could you restate the end?
I believe 4 easements have been acquired through the court process.
Thank you. And to go back to the Ag Association's line of questioning with regard to KC4, Section 3 on telecommunications easement. Does Grainbelt anticipate installing fiber optic cable during construction of the transmission line or at a later time?
Yeah, so this is, I think, probably worth clarifying what was said previously about telecommunication easement. So I believe looking at C, that could be interpreted as including third-party fiber optic communication. And the company, I'm aware, in the past has discussed the possibility of installing fiber for rural broadband on the line. This telecommunication easement language is not in involuntary easements. For the installation of easements, for installation of communications, there is communication cables that are necessary for the operation of the line. And I believe Aaron White noted that in his testimony, and those would be presumably installed at construction.
Does Invenergy or Grainbelt, do you have any plans to, I know you've mentioned, or Invenergy has mentioned previously in testimony, there's not any intentions to sell immediately that fiber. Is there any intention to lease the fiber?
I am not aware of any intention to lease the fiber.
That concludes my questions. Thank you.
Thank you. Are there any other commissioner questions? Okay. I think I may have a couple more questions, but I want to take an opportunity to look through my list and remove the ones that you've already been asked. So I think this is a good point to go ahead and break for lunch. I know we haven't been going a super long time, but this seems to be a convenient breaking point. So we'll go ahead and break for lunch and return at 1:30. If we can go ahead and go off the record. go ahead. Let's go ahead and go back on the record. So, Mr. Chandler, welcome again.
Thank you.
I have a few more questions, gonna try to fill in some blanks and hopefully it won't be too difficult. So, back on your schedule, KC4, the easement. Looking at section 2, again, the optic cable installation, telecommunications section. Is there any additional compensation for the landowners involved in that easement? That question may have been asked of you already, but
Additional compensation for
if the company installs the optic cable?
2C. No, ma'am, the compensation remains the same for the schedule that was provided earlier.
Okay. And, okay. Sorry, you answered some of these. I thought I got them crossed off my list, but I apparently didn't. Also, in section 2F, it states that except in the event of an emergency, Grainbelt will provide notice to the landowner at least 24 hours in advance of accessing the property for the first time for the purpose of construction, modifying or repairing the facilities. Will there be any attempt to mitigate crop losses by communicating with the landowners prior to planting season if construction is scheduled to begin?
So for construction, the advanced crop compensation is paid irregardless of damages. So that we are assuming damage from construction. So I think you're asking, will there be attempts to mitigate that? So certainly we will attempt to mitigate crop damages with landowners to the extent possible, but they will receive the advanced crop compensation irregardless.
Okay, but basically the easement says 24 hours and the company, as part of that mitigation strategy, has the company discussed giving landowners a schedule ahead of time?
I think it's very likely that a landowner, prior to construction, the landowner will know in advance of 24 hours. I cannot say how far in advance. This, in general, I think is probably most applicable for maintenance or repairs or things like that, where they would occur during the operations period, although it does factor into construction as well. But this is, if you think about, if a maintenance crew needs to go out or some sort of or landscaping of that nature, we provide 24 hours notice, at least 24 hours notice. So that notice could come in advance of that.
On section or paragraph 4 of that agreement, it mentions the transmission vegetation management policy. Where could someone obtain a copy of that? Is that attached to the easements at all, or is that somewhere with the company where the landowners can find it?
So in section 17 of the agricultural impact mitigation protocol, there's quite a bit of language around clearing of trees and brush, and then back in section 9, there's some text detailing things like fertilization and/or seeding of disturbed soil. To my knowledge, the vegetation management plan itself has not been written yet and would become in place closer to construction.
And would the company provide that to landowners upon request or at the time the easements are established, or?
I believe so.
One or the other or both?
I think knowing that the plan itself is not in place, I think that would be something that would be more applicable on request, either closer to construction or once in operation. And part of that, again, part of the landowner or the agricultural impact mitigation protocol, outside of just the vegetation management plan, details how we will coordinate with landowners on certain practices related to vegetation management, as talked about organic farms, but also some cooperation and coordination around things like clearing of trees.
Okay, and in section 8 or paragraph 8, that's the cooperation section, it states, to the extent permitted by law, landowner hereby irrevocably waives enforcement of any applicable setback requirements respecting the location of facilities. Do you know what the effect of that provision is and why it's needed?
I don't know what the effect of that is. In terms of, in general, I think a lot of in general, I do not know what the effect would be. To my knowledge, there are not setbacks related to transmission lines in many, if any, of the communities that we are going through. So I don't know that it has a specific effect. As to why it's in there, I'm not being an attorney, could not say.
Okay. With regard to the landowner protocol and the Missouri Agricultural Impact Mitigation Protocol, those are Schedule KC5 and KC7. Have the landowners expressed any concerns about those protocols so far, or shared any industry best practices with Grainbelt beyond what is already included in those protocols that you're aware of?
Not that I'm aware of. They are, not that I'm aware of, they are accessible to landowners via the Grainbelt Project website, as well as presumably through the public service dockets.
So you also probably, do you know if any of the parties or any of the landowners have requested any additions or changes to those protocols?
I'm not aware of any specific requests to change those protocols from landowners.
And if construction is to begin during what is typically the crop growing season and the landowner avoids planting crops, oh, never mind, you've answered that one. I'll scratch that.
Okay.
What's the reasonable time estimate of the time that it takes to set transmission structures over a mile of land without the need for tree removal? For tree removal.
I'm not sure I follow the question.
How long does it take to set those transmission structures in place over the length of a mile, say?
That would be a question for Aaron White on the engineering team.
And this may be also, but do you know how far apart the lattice structures are spaced? This may also be elsewhere, but
I suspect it's filed elsewhere. I think for lattice structures, potentially maybe 1,200 feet as an average, maybe 1,000 to 1,200 feet as an average, but
okay. And the monopoles, somebody may have answered that question earlier too. How far they're spaced apart?
I believe that's filed in Aaron's testimony, but I would say between 800 and 1,200 feet would be my guess, and it just depends based on certain engineering considerations.
And again, I apologize if you've answered these, but I got a little confused. How would compensation for the Phase 2 easements be calculated?
So for phase 2, because it's an HVDC line, it would be calculated using the 110% of fair market value plus the structure payment compensation.
Okay. Have land values increased in Missouri since the first easements were entered into for Phase 1?
I don't know that I can answer that specifically. I think land values in general have been rising, but I don't know that I have the information in front of me right now to say to what degree since the first easements were signed.
In your SIR rebuttal testimony, on page 7, lines 3 and 4 states, if the project has not achieved an advanced stage of land acquisition, then Greenbelt Express cannot obtain financing. What's considered an advanced stage of land acquisition? Do you know? Or what did you mean by that?
So I would hesitate to put a specific percentage on that. What I would say is that would encompass, in all likelihood, a significant percentage of land with the confidence that we would be able to achieve 100% of easement acquisition prior to construction.
What do you think is a significant percent? More than 50%? More than 75%?
Not being a finance expert, I don't know that I can speculate as to what percentage would be necessary to satisfy a financial counterparty.
On page 17 of your direct testimony, at lines 10 to 11, and I'm sorry, I'm jumping all over the place.
No problem.
You stated Greenbelt Express is planning to offer easement agreements in substantially similar forms to the one attached to Schedule KC4. And on page 6 of that testimony, you stated that 100% of the landowners across the existing route in Missouri have received executable agreements through the mail. How does the version of the easement agreement that was sent to the landowners along the original line as contemplated compared to those easement agreements in Schedule KC4? Is there a difference between what was originally sent to 100% of landowners?
So to make sure I'm clear, you're asking what is the difference between easement agreements provided to landowners along the HVDC portion of the line versus the Tiger Connector portion of the line?
Yes, if unless there's more of agreement that's been,
No, so the difference is that the sample easement that has been provided to Tiger Connector landowners does include the 150% payment, with note that if required to comply with regulatory mandates specifically requiring an adjustment, meaning that if for some reason that was not approved, we would revert to in all likelihood, the previous version or something similar.
so is the easement agreement in your testimony, the KC4, and the exhibits that we've entered as 24 and 25, are those the same as what was sent to the landowners originally?
Yes, I believe that aside from the difference in compensation, the text and substance of the easement agreement itself and everything that was initially provided in KC4 is the same along either the Tiger Connector or HVDC route.
Okay, I think that's all the questions I have, and I'll give the commissioners one last opportunity. No more? Okay, then. Is there any further cross-examination based on questions from the bench from MEC?
No, Your Honor, thank you.
From Sierra Club?
No, thank you.
Renew Missouri?
No, thank you.
Public Counsel?
Thank you, no.
Staff?
Brief, Judge. Mr. Chandler, just got a few questions to follow up from Commissioner Holzman's line of questioning from earlier. Are you aware of what the average size of the easements the company is pursuing for the Tiger Connector?
Average size in terms of right-of-way or per acre?
Per acre.
I'm not.
And also, are you aware if the company has ever received a variance on vegetation management from the commission?
I am not aware.
And also, right now, currently for the Tiger Connector, we're looking only at lattice structures, correct?
For the Tiger Connector, we are presuming monopole structures.
Sorry about that. And has the company looked at any, if the structures were to have to become different from monopoles, has the company done any kind of analysis of how that could affect the 150% market value payments?
We have not conducted that analysis.
Do you know if an easement is signed regarding a monopole structure and then the structure is changed to, let's say, a lattice structure, would the company have to revise that agreement with the landowner?
Are you speaking for the Tiger connector or for the HVDC route?
Tiger connector.
So because as proposed, there are no structure payments included. So I don't believe we would have to modify the agreement should structure types change, but to be clear, the intention is to use monopole structures for the Tiger connector.
And then, I guess going back to phase one, would there be any kind of renegotiation if the structure's changed on phase one? For the HVDC line, sorry, not just the tire connector, but let's say if instead of lattice structures for the HVDC line, the structure has changed, would those easements have to be renegotiated?
Sorry, if just give me a second, I'm reviewing the structure estimate and advanced crop compensation calculation for the HVDC line.
Take your time, sir.
Yeah. So the number of structures, the number for the HVDC line, the number and type of structures to be placed on a landowner's property is not something that is, it's something that is not finalized until shortly before construction. So what's clear in the structure estimate that's provided to landowners and in the Exhibit D is that the number, it's an estimated number of structures. As we make micro-siting adjustments, the placement of structures could change along the route. And so that final total is not something that is determined until a little bit closer. So there would be no change to the easement. The final payment would be, the structure payment would be based on the final number of structures that are installed on the property.
And then looking at that Exhibit D again, if, let's say it's not a lattice structure, has the company done any kind of analysis of how that price per structure would change if it's not a lattice structure, if the structure is changed later on?
Yeah. So the per payment structure for lattice is $18,000 per structure, and the per structure payment for monopoles is $6,000. And the difference between those are really designed to recognize the difference in footprint between the tower types and yeah.
And then saying that if the structures were to change, has this company done any kind of analysis of the overall cost of the project regarding that switch?
Yeah, I am not aware that an analysis has been done. Mr. White on the engineering team would be more familiar with the difference in cost on various structures.
Okay. Thank you, Mr. Chandler.
Okay.
Is there any further cross-examination based on bench questions from MLA?
Thank you, Judge. Yes. Hello.
Hello again.
I was a bit confused by an answer you gave to Commissioner Holzman regarding the percent of easements which had been, or which I think you said, which had been acquired in Missouri.
Yes, sir.
We established this morning, did we not, that Grainbelt has only less than 54% of the easements it needs in Missouri?
No, I disagreed with that statement earlier this morning. We have acquired approximately 60% of easements across the entire project in Missouri.
Do you have a copy of your responses to our data requests?
I do, yes.
you find KC2?
Yes. I do have that.
The question was, with respect to page 6, lines 7 to 8 of your testimony, what % of the easements on the original project in Missouri has Greenbelt secured? And your response was, as of November 21, 2022, Greenbelt has secured roughly 53.8% of the easements in the original project in Missouri, correct?
That was true as of November 21st, 2022.
And you're saying that's no longer true?
No, I'm saying we've acquired further easements since November of last year.
Did you update your response to our data request? Did anyone tell you that you're supposed to update your response to our data request if things
Objection, that
change?
calls for a legal conclusion.
Okay, did you update your response to our data request?
I don't recall doing so.
And that 53.8% for the original project you're saying is now what?
I would say approximately 60% at this point in time.
That's all I have, Judge.
Thank you. And is there anything from agriculture associations?
I had no further questions, Your Honor.
Thank you. Mr. Hollander? Ms. Stimmy? Associated Industries?
No questions, Judge. Thank you.
Is there redirect?
Yes, please. Mr. Chandler, do you have a copy of the routing study? Which is Schedule AB2?
I do.
Sorry, one of my documents seems to have gone missing. I have another copy, though. Could you please turn to page 36 of 87, and I'm using the numbers in the bottom right-hand corner.
I'm there.
This is with regard to some questions you received regarding how the routing team reviewed and incorporated public comments. Could you please read the first paragraph of section 4.4.2?
Yes, it says immediately following public meetings, the routing team met to review comments that were written on comment cards or maps, shared in conversation with project representatives, and submitted online via the virtual meeting. In addition to making the routing team aware of general landowner concerns about the project, these meetings provided an opportunity to revise the potential routes where feasible based on new information provided by landowners and technical guidance provided by the engineering team. Revisions to the potential route network included eliminating potential routes are shown in the refined potential route network on map 4.
And were you a part of those meetings to review the public comments?
I was.
And are you aware if those resulted in modifications to the route?
Yes, they did result in modifications to the route.
And is that section 4.4.2 of the routing study, does the remainder of that section walk through the specific modifications that were made?
Yes, it walks through a number of specific modifications made.
Thank you. You were asked several questions about the difference between the proposed 150% of fair market value payment structure versus the 110% plus structure payment structure. And do you recall those questions?
I do recall those questions.
And are you aware that in Missouri Landowners Association statement of position, they suggested that the company should offer either or of those payment structures to each landowner and let the landowner decide which payment structure was best for them?
I am aware of that.
Could you discuss what practical challenges may arise if that type of compensation was required? And by challenges, I am referring to challenges both to the company and to the landowner.
Sure. So starting with challenges to the company, it would be difficult and probably confusing to have separate payment structures for several, for various landowners along the same route of the line, as our team that processes those payments would have to navigate the differences in those payment structures, and it becomes challenging just from a processing and record keeping perspective. To the landowner, it could actually be challenging as well. As mentioned in response to one of the other questions, because it is impossible for us to say with any certainty how many structures a landowner will definitely receive as part of the project, we would be asking them to make a choice based on incomplete information.
And presumably, the company would still offer payments over time or lump sum payments under either or scenario?
Yes, it is our intention to offer the option between lump sum or annual payments for all landowners across Grain Belt.
So if the landowner was offered 150% of fair market value, there would also be two branches of that option, which would be lump sum or payment over time, correct?
Yeah, there would be two options under that scenario, and then two further options under the other scenario as well. So four different payment options for landowners to choose from, but also for our team to navigate in terms of processing and making those payments as well.
And in your opinion, you've testified that the vast majority of landowners under the Tiger Connector will receive greater compensation under the 150% fair market value structure, correct?
Yes, correct.
And so generally, from a general public interest perspective, is the confusion that and challenges that you just discussed what's your opinion when when weighing between what you think is in the public interest between giving landowners these 4 options versus giving them the one option and the confusion that would create? Sorry, that was not a very well stated question, but hopefully you understood what I was getting at.
Yes, no, I mean, knowing that the vast majority of landowners along the Tiger Connector route would be, in most cases, significantly better off with the 150% payment structure, it is our assumption that in the overall public interest for landowners along the route, that the 150% is the better option, both for, for that reason.
To the extent a landowner feels that the 150% fair market value offer does not adequately compensate them in their specific situation, is the company willing to negotiate?
We approach every conversation with landowners as a negotiation, and the initial, we make an initial easement offer and attempt to build a relationship with the landowners and have conversations with them about valuations specific to their property.
You mentioned previously that the landowner protocols, the code of conduct, the agricultural impact mitigation protocols establish a high standard for landowner interactions for grain belt. Do you recall that testimony?
I do recall that.
Are employees and representatives of grain belt who come into contact with landowners given training on upholding those high standards?
They are, yes. We conduct trainings specific to the code of conduct and agricultural protocols and the landowner protocols with both grain belt employees and with company representatives.
Is that true if there's someone new joining the team as well?
That is true, yes.
Do you recall discussions of the payment over time option? I believe that was referred to occasionally as a payment in perpetuity.
I do recall that.
Is payment in perpetuity the most accurate term, or is there a better way to think about that?
I think the accurate way to consider that is payment for as long as the easement is in effect.
Okay, those are all the redirect I had. Thank you very much.
Judge, I would request recross based on that redirect.
I'm not sure. Can you be more specific, Mr. Hayden?
I would request to recross the witness based on at least the first few questions that the company has asked this witness in the redirect.
Was there some new information or?
Yes. I think there was new information to me based on the testimony elicited as to why they could not give both options to landowners.
I'm going to allow it just this once. We're not
quick.
gonna make a habit.
I-
But I understand that the answers to that question were a little confusing, so I will allow you to ask a few more questions.
And I'll be brief, Judge, thank you. I just want to make sure I understand what you're saying about the public policy or the public interest elements of allowing two plans. We've heard testimony all week. You would agree this is a complex project that's going to cross 4 states ultimately, correct?
Yes,
And have hundreds of landowners on it, correct?
yes,
And it's going to move a lot of electricity across the country if it works out the way it's supposed to, correct?
correct.
So you have mathematicians, engineers, and economists working on this project, correct?
I can't speak to the specific backgrounds that you're mentioning, but we do have a wide range of subject matter experts.
And is it your testimony today that it would be too confusing to track 4 variables and paying out to landowners? Is that really your testimony?
It would be burdensome on the company, and so because, not only are we tracking different options, but we're also tracking different valuation calculations based on 110% or 150%. And I think knowing that it is not feasible for us to give landowners a guaranteed structure payment, we're not able to give them a guaranteed number of structures on their property until close to construction. So we'd be putting them in the position of making a decision based on this incomplete information. And then I think that, coupled with the, having to manage different payment structures, it would be significantly burdensome on our accounting and accounts payable departments.
Do you think the company would entertain an offer to create an Excel spreadsheet that would automatically do that math for them from the agricultural associations? It's a facetious question, I'm sorry. But, okay, you've answered my question. That's all I had, Judge. Thank you.
Mr. Schulte, would you like any further redirect?
No, thank you.
Thank you. Okay, Mr. Chandler, I believe that concludes your testimony.
Thank you, Judge.
You may be excused. Right, I think we can move on to Greenbelt's last witness, and who is only available today, so we will complete his testimony one way or another today.
Musical chairs, sorry, Judge.
That's fine. Could I get you to raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. And if you could state and spell your name for the court reporter.
Yes, my name is David, D-A-V-I-D, Loomis, L-O-O-M-I-S.
And whenever you're ready, counsel, take your time.
Good afternoon, Dr. Loomis. Could I get you to state your name and business address?
Yes, my name is David Loomis. My business address is 2705 Colby Court, and that's Bloomington, Illinois, 61704.
And by whom are you employed, and what are your position titles?
I am president of Strategic Economic Research, LLC, a consulting firm that I own. I am also professor emeritus professor of economics at Illinois State University.
Okay. Are you the same David Loomis who filed direct and surrebuttal testimony and accompanying schedules DL1 and DL2 on January 18th, 2023, and May 15th, 2023, and marked as 21 and 22 respectively. Exhibits 21 and 22 respectively.
Yes.
Okay. Do you have any additions or corrections to make to your testimony at this time?
Yes, I have just a few. On my direct testimony, page 3, line 4, I'd like to insert the word emeritus, EMERITUS, after professor. At the time that I wrote this, I was professor of economics and employed at the university. As of June 1st, I've retired, and so I retain the title of professor emeritus.
Okay. Do you have any other additions or corrections to your testimony?
Yes. On my surrebuttal testimony, page 3, line 4. Again, I would insert emeritus after professor.
Okay.
And then on page 5 of my surrebuttal testimony, footnote 2, I'd like to change Sarah Lange to Krishna L. Podel, Poudel, comma, PhD. I attributed that statement to the wrong individual.
Thank you. Other than those corrections, do you have any other additions or corrections to make to your testimony at this time?
No.
Okay. And other than the changes you noted, if I asked you the same questions again today, would your answers remain the same?
Yes.
Thank you. I would move the commission to enter exhibits 21 and 22 into the record.
Would there be any objection to exhibits 21 and 22? Seeing none, I will admit those exhibits.
Thank you, Dr. Loomis. I have no further questions. Your Honor, I tender the witness for cross-examination.
Thank you. Is there any cross-examination from MEC?
No, Your Honor, thank you.
Sierra Club?
No, Your Honor, thank you.
Renew Missouri?
No, thank you.
Clean Grid Alliance?
No, thank you.
Public Counsel?
Thank you, no.
Staff?
Brief, Judge. Good afternoon, Dr. Loomis.
Good afternoon.
I just wanted to get your definitions of a few economic terms for the record. How would you define economic feasibility?
Economic feasibility really deals with a forward-looking standard for a project, and say whether the revenues for that project would be sufficient to cover the expected costs.
Thank you, sir. And how would you define economic viability?
I guess I would put those together in terms of a feasible project and a viable project, and be synonymous.
And then how would you define revenue certainty?
I'm not sure I have a good definition for that out of context.
And then how would you define financial feasibility?
I guess if I had to look at those differently, financial would include the ability to procure either debt or equity financing in order to do it. So the difference in my mind would be that it might be economically feasible, but you'd need to get investors and the capital to actually do the project, so it would be financially feasible.
And would you also see financial feasibility as the same as financial capability?
Yeah, I think if you're financially capable, it'd be financially feasible.
And last question, Dr. Loomis, to maximize the benefits that you describe in your study, does the entire project need to be constructed to maximize those benefits?
To maximize the benefits, the whole project would need to be built, yes.
Thank you for your time, Dr. Loomis. No further questions.
Are there any questions from MLA?
Thank you, Judge. Good afternoon, Dr. Loomis.
Good afternoon.
In making your estimates of the economic impact of the project, you used what is called the M-Plan computer model, IMPLAN, all caps. Is that correct?
That's correct.
Could you turn, please, to page 8 of your direct testimony?
Okay.
Looking at line 3, is it correct that using the M-Plan model, you estimated that for the 3-year construction period of the project, it would produce the full-time equivalent of about 5,747 new construction jobs in Missouri?
It would create or support that number of jobs, yes.
And that's the total for all 3 years?
That's correct.
And at line 11 of that same page, you state that the total earnings impact from these construction jobs would be just over 586 million in Missouri. Is that correct?
That's correct.
And that's also a total for 3 years, correct?
Yes.
Do you know how many of those one-time construction jobs would be filled by residents of Missouri as opposed to workers who move from one transmission project to the next?
That would be dependent on the hiring practice of the contractor that would do that.
So you don't know?
I can't say for certain.
Well, workers do move from one-time jobs to the next, do they not?
That's correct.
Your study assumes that the construction work in Missouri would be filled 100% by residents of Missouri, does it not?
That's correct.
The wages and job figures we discussed are what you would consider positive impacts from construction of the project, correct?
I estimated both construction and operations, but that's correct.
Positive impacts.
Positive impacts.
Isn't it true that the M-Plan model is also capable of accounting for negative economic impacts of building a project like the Grain Belt Line?
The software is capable of estimating impacts depending on how you put in those variables. So yes, it's capable.
Positive and negative.
Yes.
When running the M-Plan model in this case, isn't it true you did not account for a single negative economic impact from building the Grain Belt project?
My analysis was limited to looking at those impacts for construction and operations of the line.
So the answer is no, you didn't consider any negative impacts.
And I also did not consider some positive impacts.
Correct, but my question was about negative, and your answer is you did not consider any.
I did not have negative impacts in my study.
Did you read the testimony of Mr. Petty in this case?
Yes.
At page 9 of his direct testimony, Mr. Petty estimated that the addition of the Grain Belt project will mitigate additional generation capacity investments of approximately 526 million per year, or 7.6 billion for the life of the project. So my question is, if his assessment is accurate, some generation projects will not be built because of the addition of the Greenbelt line. Is that correct?
I don't have his testimony, but assuming that that's what his study said, yes, I did not include those numbers in my analysis.
And for each of those projects which are not built, there obviously would be no jobs or other benefits created by these unbuilt projects, correct?
I'm sorry, I'm lost in the hypothetical. In his testimony, was he saying that those other generating plants would have been built except for this line? So there's new generation that will not be built because of the line, or?
That's essentially correct. There's new generation that will not be built because of the Greenbelt project.
Okay, and so could you restate the question?
Sure. And for those projects which are not built, there obviously will be no jobs or other benefits created by the unbuilt projects.
I did not put that into my model.
The loss of the jobs.
I did not account for those numbers from his study in my analysis.
And it's not just the initial construction jobs which are lost, but also the O&M jobs over the life of those plants, correct?
Again, if these hypothetical new plants were built, it would include both the construction impacts and the operations impacts.
And so if they're
Jobs.
not built, there's a negative impact both from construction and from the ongoing O&M process, right?
Again, in this hypothetical, that's correct.
Beginning at page 11 of his direct testimony in this case, beginning at line 21, Greenbelt's witness, Mr. Repsher, testified that the supposedly low-cost power from the Greenbelt project will displace higher-cost power from inefficient generators in MISO, at Associated Co-op, and in other areas. If power is displaced from Associated Co-op, for example, that means that Associated would be producing less power than it would have without the Greenbelt project, right?
Could you state the question again?
Sure. If power is displaced from Associated Co-op's plants, just as an example, that means that Associated would be producing less power than
Objection.
it would have been without the Greenbelt project.
Mr. Agerton, can you point to where in Mr. Repsher's testimony he says that associated co-ops would be shut down?
I didn't say shut down.
Can you point to,
At page 11, beginning at line 21, he testified that the supposedly low-cost power from the Greenbelt project will displace higher-cost power from inefficient generators at MISO, at Associated Co-op, and in other areas.
and your question based on that testimony was?
If power is displaced from Associated Co-op's plants, that means that Associated would be producing less power than it would have been without the Greenbelt project.
I don't agree. From the word displaced doesn't mean that it is shut down.
No, I'm not
Or that
saying,
there's no other, I think that your premise would only be true if that generating plant was not, was shut down.
I'm saying that it is producing less power because of the Greenbelt project.
Objection. I don't believe that's what Mr. Repsher's testimony states. It says that it displaces higher cost power, but it never states that there would be a corresponding reduction in power from another generation facility. So I think you're assuming a fact that's not currently in evidence.
I disagree. He said that it would displace, the grain mill project would displace the output from other plants.
The testimony says displaces higher cost power from inefficient generators in MISO, SPP, and SERC AECI. So inefficient generators in those areas. So that seems to say what Mr. Agathon's question is asking.
Do you remember the question?
Yes. So when you're, just because you're displacing that electricity, I'll go back to the case, you really need to say that you're shutting down that generating unit. Much of the costs of a generating plant are fixed costs, even in some cases, the labor in operating a plant, whether it's running at 40% capacity or 80% of its capacity, typically the same number of employees would be working. If it's a fossil fuel plant, there would certainly be savings in terms of the fuel costs. But the premise in terms of displacing isn't accurate. I think you have to go all the way to say, no, the plant was shut down and is no longer in operation for you to definitively say that there's going to be job losses.
Well, what if, and I'm not talking about job losses at this point, but what if a plant in associated area or anywhere else that we're talking about here, their power production is cut back because of the grain belt line? Is there a negative consequence there for that power plant?
It would depend. And as I said, there would be less, in my hypothetical, there would be less fuel that would be utilized, but then it would depend on where that fuel is sourced from. Many coal plants get their coal from the Powder River Basin because it's low sulfur coal. In that way, the decrease in coal usage would be felt in Wyoming in the Powder River Basin rather than coal producers here in Missouri.
Did you consult with Mr. Repsher about the amount of power which he believes will be displaced by the grain belt project?
No, I did not consult with him.
If enough power is displaced by the grain belt line, it could also impact the need for O&M expenditures at that plant, could it not?
Yes.
And that would logically reduce the amount of labor involved in O&M operations, right?
No.
Well, for example, if the power plant shuts down one unit, they're not going to have to clean the boilers there, right?
Yeah, so you would have to add that condition to your statement. It just does not logically follow to say operations and maintenance costs are reduced, therefore labor is reduced. You have to go into the specifics. So if, in your case, if you shut down a unit and you no longer have to perform maintenance on that unit as a whole, yes, in that example, but you've now set more conditions and provided some more information. It's not the general case where operations and maintenance expenses reduced will reduce the labor expense.
Let me ask you this. Does your in-plan model reflect any of the consequences of reduced power production at other plants in Missouri?
No.
On a related subject, did you do any kind of analysis to determine the negative impacts from the line on the elimination or deferral of utility demand-side programs?
Restate the question, please.
Did you do any kind of an analysis to determine the negative impacts from the line on the elimination or deferral of utility demand-side programs?
I'm just failing to see the linkage between the line and the demand-side management programs.
But your analysis did not take into consideration any impact on demand-side programs?
Objection, assumes facts, not in evidence. Mr. Agathan hasn't laid foundation for a link between the project and demand-side programs.
I'm going to overrule the objection. He can answer whether he considered it, or if he doesn't think there's a link, then.
I failed to see the linkage, and therefore I did not consider it relevant to be included in my analysis.
Okay, so I think we can cut this short. Your analysis did not include any impact from demand-side programs.
That's correct.
Thank you. Could you please turn to page 5 of your direct testimony? You have it?
Yes, I'm at page 5.
Beginning at line 14, you distinguish between the direct and indirect effects of a construction project like the Greenbelt line, correct?
Yes.
And the direct effects include such impacts as the spending on wages?
Yeah, those are the spending and wages of employees of Invenergy or their contractors.
Sure. And the indirect effects are production changes resulting from the changing input needs of a directly affected industry, such as steel purchasing to be used for the support structures. Is that generally correct?
Yeah, those are looking at those supply chain impacts of those industries that would be providing materials.
And those are the indirect impacts.
Correct.
Assuming that the Greenbelt line does result in negative direct effects, such as from the elimination of generation or transmission projects, given that assumption, then it would also result in negative indirect effects associated with those eliminated projects, correct?
Again, I don't believe that there's going to be those negative impacts in the hypothetical question. And then, again, the linkage, I'll go back to my coal example. It will depend where those supply chain impacts are felt, where those supply chain materials and so forth are being sourced from. If it's out of state, then there would be no impact to Missouri, like in the case of Wyoming coal.
You're not saying, are you, and we're going back a couple of questions earlier, You're not saying that there's no negative impact if a plant is not built at all because of the Greenbelt project, are you?
I'm not agreeing with the premise that there's a linkage between the line and the generating asset not being built.
So you don't think that the Greenbelt project would put plants that would otherwise have been built in a status where they economically will not be built? You don't think that that's the case?
Again, that would be a different analysis to look at. It assumes that there's a zero-sum game such that if you added one thing, it will necessarily mean that you're going to decrease something else. And I don't think that's the case here. I think we're looking at electricity demand growing.
Despite the testimony of Greenbelt witnesses in this case to the contrary.
Objection mischaracterizes the evidence. I don't believe any Greenbelt witnesses have said that there's going to be a decrease in the amount of electricity in the system.
No, not a decrease in electricity, but that plants will not be built because of the Greenbelt project.
Again, I don't think any Greenbelt witness has said explicitly that there's going to be a plant that will not be built because of the Greenbelt project's existence.
Well, I'm referring to the testimony that we covered earlier, and I hate to have to go back and reread this, but at page 9 of Mr. Petty's direct testimony, lines 11 to 13, he estimated that the addition of the Greenbelt project will mitigate additional generation capacity investments of approximately $526 million per year, or $7.6 billion for the life of the project. So, Your Honor, I think there certainly is evidence in the case that, according to Greenbelt, there are projects that will not be built because of the Greenbelt project.
Okay, I will overrule the objection.
You want me to repeat the question?
Please, thank you.
Assuming the Greenbelt line does result in negative direct effects, such as from the elimination of generation or transmission projects, then it would also result in negative indirect effects associated with these eliminated projects.
Again, assuming that premise is true, you would have to look at where the supply chain impacts are coming from. Where are the source materials?
Sure, but there would be negative impacts somewhere.
Somewhere. It might not be in Missouri. It could be overseas.
Do you know who's supposed to construct the Greenbelt line? What workers, from what locations?
In our study, we assumed that those were going to be local construction workers.
Isn't it logical to say that those same areas would be the source of workers for plants that are not built?
That's going to depend on company hiring processes.
But it certainly could be.
It is possible.
I mean, isn't it likely?
Again, it will depend on a host of factors, including, again, their hiring practice, what kind of generation it is. you know, if it were, I'll just give you, again, we're in the land of hypotheticals, right? If we're building a new nuclear power plant, there may be specialized expertise in that's not contained in Missouri. Okay, so I don't think you can just say for sure what those impacts are going to be. You'd have to study that.
Do you know where the workers came from that built the Callaway nuclear plant in Missouri?
I do not.
Would you agree that if the Greenbelt project is to be economically feasible, it will need to recover its cost of doing business?
Cost recovery is a regulatory construct, and I believe this is going to be a merchant plant. So I wouldn't use that terminology for a market-based.
Well, it's going to incur costs, is it not? Greenbelt project.
Could you restate the question?
Would you agree that if the Greenbelt project is to be economically feasible, it will need to recover its costs of doing business?
So I would say that if it's going to be economically feasible, the revenues from Greenbelt Express would have to exceed its costs.
Thank you. And would recover those costs from entities buying capacity on the line, correct?
I'm not familiar with how they would structure the products that they're selling, to say that for sure, but they would have to have revenue sufficient to cover their costs.
So for example, if they sold capacity to Ameren, that would cover partially at least the cost of the project.
Yes.
In the normal course of events, if an end-use supplier such as Ameren purchased capacity on the Greenbelt line, it would expect to recover the cost of that capacity from its retail customers, correct?
I believe that's a decision for the commission. They would be in the position to say what is allowed in rate base, whether it's used and useful, whether it was prudently incurred. That would be a commission decision that Ameren would have to request that to be allowed in rate base.
If it was a prudent decision to buy capacity, Ameren certainly would expect to recover those costs from its retail customers, would it not? I mean, it's not going to go out and buy capacity that it's just going to lose, obviously.
They would have the expectation, certainly, but it would be the commission's decision as to whether that actually gets recovered in rates.
Sure, and my
they don't
question
have
was, wouldn't Ameren expect to recover those costs?
They would, if they prudently incurred that capacity and it was used and useful, they would reasonably expect for that to be recovered in rates as a regulated utility.
Could you turn to page 6 of your schedule DL-2?
DL-2. Okay.
In the right-hand column there, you state that local governments in Missouri will be paid millions of dollars by Greenbelt in property taxes, correct?
I state that the first full year property taxes would be $13.9 million.
And the money paid by Greenbelt for property taxes will ultimately be recovered in the costs of capacity paid to Greenbelt, correct?
They would pay that out of the revenues that they would receive
So
from
the
the
answer-
project.
Answer is yes.
I guess could you restate the question?
The money paid by Greenbelt for property taxes will ultimately be recovered in the cost of capacity paid to Greenbelt.
That would be the plan, yes.
And if the capacity is purchased by an end-use provider, again hypothetically Ameren, the utility would normally expect to recover those costs from its retail customers, correct?
Again, the expectation would be, but that would be a commission decision.
Sure. I'm well aware of that. So you list the property taxes, let me strike that. Could you turn please to Schedule DL-2 to your testimony?
Yes.
Looking at the middle of page 6 of 27, your study assumes that the total investment in the project from Greenbelt will be $7 billion, correct?
Yes, the line actually says the Greenbelt Express transmission line represents a $7 billion investment by Invenergy Transmission.
Right. Was that $7 billion figure given to you by someone from Greenbelt?
That $7 billion includes both the upfront capital expenditure for the project, as well as, I believe it was the first 30 years of operations. So the capital expenditures was provided by Invenergy. The operations and maintenance figures were provided by Invenergy, but I think I did the calculation to come up with that total of $7 billion based on their numbers.
So that's not just for the construction of the Greenbelt line.
That's correct. That represents an investment of both the construction costs and a minimum of first 30 years of life in terms of operations and maintenance expenditures.
And did you base your calculations of the benefits, the savings from wages, et cetera, on the initial construction of the project, or did you also add in all these ongoing costs you've been talking about?
So I did two separate models. The first model was the impacts during construction, and the second actually set of models was the ongoing annual impacts during the life of the project. So I separated those two out.
Understood. Is it fair to say that Greenbelt did not ask you to look at or quantify any of the negative consequences which might result from its project?
Sorry, Mr. Agathon, I missed that question. Could you ask that again?
Is it fair to say that Greenbelt did not ask you to look at or quantify any of the negative consequences which might result from its project?
They did not ask me, they did not limit the scope. This report is typical of the types of reports that I produce for other energy projects. So there was nothing particularly in this report that Invenergy asked me to tailor to this specific analysis. It's the analysis that I typically performed for energy projects.
But there are models which are capable of quantifying at least some of the negative impacts that are caused by a project like the Greenbelt line, are there not?
I suppose certainly there are others who would may look at that.
Through a different model?
Yes.
Would you agree that if you determine that a project will produce certain economic benefits, such as jobs, that it's still important to determine the net impact after taking into account the economic detriments?
If there are economic detriments and you can quantify them, they should be taken into account.
And the net benefits, net, of any project, including Greenbelt line, would be the difference between the positive benefits and the negative detriments, correct?
Yeah, I think as I've already stated, in addition to agreeing with you that I did not include some of those, what you've posed as hypothetical detriments, there's also benefits that I did not quantify.
I understand, but we're looking just at the testimony and studies that you presented here, right?
Right, so my study looks at the economic benefits of construction and operations of the line.
On a different subject, in estimating the positive impacts of the project, we've established that one input to your model is the wages, salary, and benefits of the workers who would be employed in construction of the line. Is that generally correct?
Yes,
And those wages and benefits figures were provided by Greenbelt to you?
they provided a breakdown of the capital expenditures that also included their expected labor expenditures.
So the labor expenditures were given to you by Greenbelt.
That's correct.
Were those gross wages?
Yes, those were gross wages that they expected to pay.
And that would include an amount which will be withheld for various reasons from the workers, just like federal income taxes, for example.
Right. Typically, when we look at earnings, in my report, I'm looking at both wages and benefits. So it's a kind of total compensation package, and as you're well aware, there's going to be money deducted from that. So the net pay that a worker will receive will be less than the total earnings that I list in my report.
Okay, so the workers will not receive all of the wages that you have used in your report.
That's correct. In addition to those deducted from the employees' wages would obviously be the employer side of Social Security tax. That would be in that number as well in terms of total earnings, but obviously they are not getting directly compensated for that.
Other than income tax deductions from the paychecks, are there other deductions as well?
I think taxes are going to be the big one. In a model like IMPLAN, they don't think that they go down to the specificity of like for example, a 401K plan where it could be deducted from your pay, but then it's still yours, it goes into an account and so forth. I think this is more of a global picture of earnings, but there would be other deductions like that.
Other deductions that the workers do not receive any benefit from. In the example you gave of a 401K plan, that's not really a loss to the worker. But are there other deductions which are, like taxes, a real loss to the worker?
I would object to the extent that you're implying that paying taxes doesn't somehow return a benefit to the employee.
I'm not implying that at all. I'm just saying that the figures like Dr. Loomis has included for wages, which he attributes to be benefits for the Greenbelt line, he's saying that the gross pay is what he included, and I'm simply asking, aren't there deductions so that his figures are in effect overstated?
With regard to the question that you specifically asked, and to the extent that it implied paying taxes was not a benefit to the employee, then I'll sustain that objection. But I think you can rephrase your question. However, the witness has said that he used gross wages.
Okay, just to clarify, Your Honor, I hope I'm not repeating here. The figures that you use in your study are gross wages, right?
It's not only wages, but wages and benefits.
Right.
So
Understood.
it's total compensation.
Total compensation, but you've included the gross amount of the wages.
Right, this is not net. This does not represent the final paycheck that the worker is going to receive at payday.
Okay,
Yes.
I think we're good. On a different subject, does the in-plan model reflect any negative consequences associated with accidents and worker injuries which could occur in building a transmission line over 200 miles in length?
So to be clear, the in-plan model is looking at relationships between industry segments in the economy. So if you were to quantify some type of impact from construction workers, you may be able to get in-plan to give you estimates of the total economic impact of that. But probably more to your point, I did not quantify any type of input like that, nor did I run an in-plan model to quantify that.
Thank you. Your Honor, at this time, I'd ask the Commission to take administrative notice of one page from the transcript of the first Greenbelt case. That was EA 2014-0207.
for the benefit of those online, that you said that was page 1500 of the transcript. Lines 4 through 18.
Yeah, so we're gonna object to this for a few reasons. First, this is a series of 1, 2, 3 questions and answers that Dr. Loomis gave to Chairman Kenny in the EA 2014 case, without including the entirety of Dr. Loomis's testimony. At an initial level, it seems improper. Second, Dr. Loomis's analysis in the 2014 case would have been according to the specifics of the certificated project, as opposed to the amended project. So all of the numbers are different too. So I don't know if it's fair to cherry pick this section of his previous testimony without more context, at least.
Mr. Agathan?
Yes, Your Honor. If a witness has said something during the course of a hearing, it would be virtually impossible to continually bring in the entire transcripts of testimony, not only in this instance, but for other cases of impeachment. It would just be too cumbersome a process, and there's really no reason for it. These words on this page speak for themselves.
I think the other issue that I have is, assuming you plan to use the highlighted text in terms of following the best evidence, Dr. Loomis has been pretty clear that he used gross economic benefits as his calculation tools and not net economic benefits. So I don't really see the point in bringing up a similar economic model that he used in the past when he's already answered the same questions that you've asked about the current model.
And Mr. Agathan, what is the purpose of this testimony? Are you using this of this page of the transcript? I don't.
To nail down the concept that he has not looked at any negative consequences of building the Greenbelt line.
He's answered that question.
I have to agree. I think that is clear from the witness's testimony. I'm not sure what this page from the transcript adds to that.
And Your Honor, if I could add an objection before Your Honor rules. MEC makes a straight up due process objection. We were not a party in the 2014 case, and so sworn testimony cannot be admitted against us without denying us the opportunity to meet that evidence with our own testimony or cross-examination. Since we weren't a party, that opportunity is lost. And so for our objection is straight up due process.
Mr. Agathan, do you have any other argument that you wish to make?
I don't think so, Your Honor. I'd be repeating myself.
I'm going to sustain the objections and not admit this, but I am marking it as Exhibit 303 for identification purposes, and so that it can be included in the record,
Thank you, Judge.
but not as evidence.
Understood.
Judge, since you're marking it as an exhibit, are there additional copies?
Oh, I'm sorry. We can get additional copies, but that is in the case EA 2000, right, it's EA, isn't that correct, Mr.
Right.
Agathan? 2014-0207, did I say that correct? And it's page 1500, lines 4 through 18 of the transcript,
It's obviously available on the EFS system.
yes.
I'm not asking for a physical copy now, thank you. That'll suffice.
Okay, thank you. Do you have additional questions, Mr. Agathon?
I do, Judge. I have a number of questions based on your Sir rebuttal testimony. At page 5 of your Sir rebuttal, you mentioned that you have prepared economic analyses which were used in 2 prior cases at the commission. Is that correct?
Where is that in my Sir rebuttal testimony?
Page 5.
Page 5. Yes, I prepared a report that was attached to somebody else's rebuttal testimony previous.
So you didn't
Previously.
actually present testimony in the last Grainbelt CCN case, right? That would have been EA 2016-0358.
I believe that's correct. Just the report.
And someone else submitted your report as an attachment to their testimony.
I think so.
In that 2014 case, you also used the in-plan computer model to quantify your benefits, did you not?
Yes.
Do you recall what the commission said about your analysis in that first Grainbelt case?
No.
Handing the witness a two-page, pages 17 and 25 from the report and order for EA 2014-0207.
I would point out that this is the report and order in EA 2014-0207, issued on July 1st, 2015. The commission later ruled in EA 2016-0358 and report and order on remand. The report and order on remand is what is referenced in Dr. Loomis's testimony, and not this report and order that Mr. Agathon has presented.
Well, the witness didn't testify in the last
You speak
case,
into the
or-
microphone, Mr. Agathon.
The witness didn't testify in the last case, so this is a commission finding as to the validity of his model and the use of the model to support the benefits of the Grainbelt line.
And did you hand me a copy of that item, Mr. Agathon?
I'm sorry. I'll take it back. Sorry, Judge, I did not get that from the witness momentarily.
And Your Honor, again, since this is the case MEC was not a party to, could we have just a minute maybe to look over Grainbelt's shoulder and Because we don't have a copy of what this is either, and I don't know if I need to object.
Yes.
And for the record and for people that are following along at home, this is a 3-page exhibit. One of them is a cover sheet for the report and order, issue date July 1, 2015, in EA 2014-0207. And it's an excerpted portion that begins on page 17 of the report and order, and goes, oh, I'm sorry, it's 2 different pages that are not consecutive. One of them is page 17 of the report and order. I have highlights on paragraphs 54 and 55. And then the next page is page 25 of the report and order. And I have highlighted a single sentence from the second paragraph on the page. And we need a second to review this.
Okay, I think this is probably a good place to take a break. Yeah. Okay, let's take a break for 15 minutes and return at 3:35.
Thank you.
We can go off the record. Okay, we're back on the record after a break. There was some discussion. We're going to try to stay late this evening to make up some lost time. So, where we left off was, Mr. Agathon had requested the commission to take official notice of a couple of pages from a transcript, or from a report and order in EA 2023-0017. Did I characterize that correctly, Mr. Agathon?
Judge, I'd like the witness to read in the highlighted portions from that order.
Your Honor, so I believe when we were leaving for the break, we wanted an opportunity to review to decide if we wanted to object, and we've decided to object. This is a report and order from the 2014 case, which was, resulted in the denial of a CCN, but later in the 2016 case with a revised application, the commission ruled in Greenbelt Express's favor and cited positively to Dr. Loomis's report. To the extent that Mr. Agathon wants to cite to this in his briefing, he's certainly allowed to. It's part of the commission's previous orders, but I don't really see the relevance in having Dr. Loomis read this into the record.
And Your Honor, when you're
Yes.
ready, MEC would have its own objection.
Go ahead.
Yes, Your Honor. The same due process objection that we raised to Mr. Agathon's attempt to have the witness read in partial testimony from the 2014 case. We have the same objection for reading into the record of evidence a piece of the report and order from that case, because of course MEC was not a party. And that would violate our due process rights to be present and meet evidence and perhaps rebut the evidence with our own or through cross-examination. I would echo what Mr. Pluta said. Mr. Agathon is certainly welcome to cite that in his brief, but it cannot go into the record of evidence as evidence without implicating our due process rights. And frankly, now that I've had a chance to see what it says, it's completely duplicative of what this witness has already testified to today. And so it seems to me to be an unreasonable due process risk for no evidentiary benefit.
Are there any other objections to these pages, which again, for the record's sake, I'm going to go ahead and mark as Exhibit 304. Are there any other objections? I don't hear any. I am not inclined to have the witness read in partial reports and orders. However, this is a report and order in a somewhat related case. And so while I will not admit or allow the witness to read those portions in, I would entertain the idea of taking notice of the entire report and order and putting that into the record. Would that be something that MLA would be interested in, Mr. Agathon?
That'd be our second choice, Your Honor.
And
But
would there
we could live with that.
would there be similar objections to the commission taking administrative notice of the entire report and order?
Yes, for MEC, we would renew our objections in their entirety.
Greenbelt would join in that objection. Mr. Agathon's free to cite to these reports and orders in his briefing, but I don't see the relevance of putting this into evidence.
Okay, well, I think in order for the record to be clear to the appeals court and that, and I'm assuming the appeals court may see this report and order from this hearing, but in case they do, I'm going to take official notice of the report and order in EA-2014-0207. And I know I have some pending requests to take official notice of some other items, and I will promise you all a ruling on those items tomorrow.
Judge, for the record, public counsel does not object to you taking official notice of this particular report and order.
Thank you, Mr. Williams. Okay. With that being said, do you have additional questions for this witness, Mr. Agathan?
I'm almost done here, Judge, but I do have one other document I want to give to the witness. It's a 3-page document entitled Economic Impact Analysis for Sapphire Sky Wind Farm in McLean County, Illinois. Dr. Loomis, do you recognize the document that I
Just,
sorry.
just one moment, please. Some of us haven't even seen the document. I don't know if we need to object or not. I know I don't recognize anything called Sapphire Sky Wind Farm in McLean County, Illinois. I don't know if that's another legal proceeding. If we could just have a minute to at least see it.
That's fine. Can, Mr. Agathan, I assume you have only those copies that you gave the witness, and
That's correct, Your Honor.
are you intending to offer this as evidence, or are you just going to question the witness with it?
I'm going to ask him to read in a portion of the document. I'm not going to offer it in evidence.
But Your Honor, if he reads in from the document, it is then part of the record of evidence. So I do ask for the opportunity to at least see it and understand where it's coming from.
Yes, you can take some time for everyone to look at that.
And Your Honor, Mr. Agathan's representation of what this document is a little imprecise. This is a document entitled Economic Impact Analysis for Sapphire Sky Wind Farm in McLean County, Illinois. The second page of it appears to be the first page of an executive summary. It's completely unclear whether or not there's another page of the executive summary. And then the last page is page 29 of the report. So this isn't even at all a complete representation of the document. So I've never seen this before. So I'm going to have a hard time defending my witness on the contents of the excerpt, given that it is just an excerpt and there are no other copies being presented. And it violates the rule of completeness. I'm passing the exhibit around so that others have an opportunity to review.
Your Honor, I apologize for not having enough copies for all the attorneys in the room. I thought we had, and this is probably my misunderstanding, established to the first day that I had to have a copy for the witness and for the attorney when I tried to get by with just a copy for the witness.
Unfortunately, Mr. Agathan, we need copies for the attorneys and for the bench, so that we can all be
Okay,
aware of what's going on.
I apologize. I thought that was just for exhibits that were going to be offered in evidence.
Well, in this case, it's kind of semantics as to whether you're offering this document or not, so. But we'll take a minute, let the attorneys look at it.
Your Honor, while other attorneys are reading, MEC is content to place its objections if you would care to hear them at this time.
Sure, go ahead.
Okay. We join in the grain belt objections in that this document, although the first page of it appears to be a document that at one point was authored by this witness, it is a woefully incomplete document, and the highlighted portion that Mr. Agathan has indicated he wishes to have read into the record of evidence is not even a complete paragraph, much less a complete section so that one can take it into context. And obviously, none of us, were part of that particular proceeding. I can't tell if that was litigation, but certainly MEC was not a party, and so we would raise due process concerns as well as completeness, the rule of completeness.
Does anyone else that's had an opportunity to look at it have an objection at this point?
Judge, on behalf of Associated Industries, we would join in MEC and Grainbelt's objections. It's an entirely incomplete document, and it's impossible to even inquire of the witness as to what else is in it without being able to see the full document. So we were deprived our right to cross-examine the witness on this document, so we would object.
Okay, has everyone had an opportunity to at least review that? Okay, I am not, again, inclined to let the witness read in part of a report, an incomplete report. So I guess those objections are sustained. However, Mr. Agathan, you are more than welcome to question this expert witness about other writings and items that he has authored. So,
I've run out of documents, Judge.
well, I mean,
No,
feel free to question him about that document is what I'm saying, and they'll make any objections as they go.
The only question I would have is this what you said in your document? And obviously, you've already ruled on that.
Well, I guess some explanation as to what the document is on the record might be helpful.
Okay, doctor, could you explain what that document is?
It appears to be a report that I authored. It's dated February 2021. It's titled The Economic Impact Analysis for the Sapphire Sky Wind Farm in McLean County, Illinois. I believe this was prepared as part of a permitting hearing, or was filed, and that's why it's public. Permitting hearing in McLean County for to obtain special use permits to build the Sapphire Sky wind farm.
Is that sufficient, Judge?
Well, that helps me, yes. I think that at least makes the record clear as to what we were talking about. So, I think for clarity of the record again, that I will mark that as Exhibit 305, just even though it's not admitted, it will be at least preserved in the record. If you could give that copy to the court reporter, that would be appreciated. Thank you. 305. Did you have other questions, Mr. Agathon?
I do not, Judge. Thank you.
Are there questions from the Agriculture Associations?
With fear and trembling, Judge, there are. Just a few, I think. I'm looking at this study. I'm just trying to make sure I understand some of the methodology, because I'm a little unclear on it. And I'm talking about now your Schedule DL2. And I think, if we have to go back to your direct testimony, we will. But I think I can work through this and kind of constrain us to this document. The first thing I wanted to ask you about is, and I want to find it. I just had it. I believe, it confirmed for me if I'm wrong on this, but I believe your study used 2020 data in its entirety as part of its methodology. Is that correct? And I'm looking at page 7. I found it here. Page 7, under 4.1, M-Plan, that first sentence in that paragraph talks about using 2020 data.
That's correct. That was the latest in-plan data that was available at the time that I did the report.
Okay, and 2020 was an atypical economic year for this country, correct?
That is correct.
So do you have any concerns that 2020 created inaccurate or artifact effects within your conclusion due to it being an atypical economic year?
It was, there was the trade-off between using the latest data available, which is usually a best practice, and saying, is there a problem with 2020 because of COVID and things, and I did opt to go with the latest data available rather than my other alternative at that point when authoring the report was to use 2019 data.
For your own, just for your own reference, did you ever run your 2020 data that's in the report that's in front of us against 2019 or 2018 data to see if you got different results?
No, I did not.
Okay, and so, I want to make sure that I understand. I mean, some of your numbers here are projecting gross job growth from this project, correct?
Say that phrase again, gross job growth?
Right.
Yes.
Okay, and so, and I guess that's what I'm concerned about, just so I'm clear, you're projecting into the out years over the top of 2020 numbers when we had suppressed, well, I guess it's a fact, I'm assuming a fact, not an evidence, but I think we all know we had fewer people working in 2020, and your charts would bear that out for regulatory reasons induced by the pandemic. I mean, is that going to inflate the numbers and inflate the economic benefit that you're going to find from this project by using 2020 numbers?
When you're using the in-plan data, really in-plan is an input-output model that's taking different sectors of the economy and measuring how they're related to one another, those cross-industry relationships. So I'm not concerned with that in the sense of kind of overinflating the numbers as you've stated.
Okay, so going back then to page 5 in your report. This is still, and I know I keep saying your report. If you want me to call it something different, let me know. But this is DL2 that I'm talking about. Your analysis, I guess, is what it's called in the top page. On page 5, you show charts there. For example, that very first chart shows total employment, 2010 to 2020 in Missouri, correct? Figure 3.2.
Yeah, this is just the table of contents rather than the actual figure.
Okay. And a couple questions about that. That's that's employment based on absolute numbers, first of all, correct? I mean, by that I mean absolute individuals involved in employment on page 5. Is that what that number shows on that chart on 3.2?
So if we turn to the actual page, I believe it's page 10 of
Okay.
27, you can see the total employment numbers. At the bottom of figure 3.2, it lists the source, which is the Bureau of Economic Analysis, to provide those numbers from 2010 to 2020.
I'm looking at page 10 here. What does your page 10 say at the top? Are you looking at the red numbering in the bottom right?
I am.
I'm sorry, I'm looking at your page numbering at the top. That's why we're sideways here.
Okay, thank you. We're together now.
Okay, okay.
Page
Let's,
5, yes.
for ease here, because it is the record, and I apologize, let's use those red numbers at the bottom.
Okay.
So it's really what I was referring to as page 10 is page 15 of 27. You're on page 10 of 27?
Yes.
Great. Just a second, let me
We're
find
on the
that.
same page.
We are on the same page. Okay, that was page 5. That's what I meant. All right. Sorry. So going back to that chart then, figure 3.2, page 10 out of 27 for the exhibit. That is a absolute employment number, not a employment or unemployment percentage number, correct? That showed.
Right, that's total employment, total number of employees, total employment.
Do you know as you sit here today whether that number has gone back up since 2020 in Missouri?
I can't say for sure.
Do you
I
think it
don't-
probably has?
I think it probably has.
Do you know what the unemployment percentage is in Missouri today?
No, I don't.
Do you know what would be considered full employment for Missouri? Like as an economist thinking about that term?
Right, that is the subject of lots of controversy within economics because when I was in grad school, we would have said, yes, where we're currently at would be full employment. But what's different now is things that are happening in labor force participation. So taking workers that were out of the workforce, and economists are not exactly sure why. And so when you look at an unemployment rate, it assumes the denominator is people who are looking for employment and doesn't take into account directly that labor force participation rate, where you say, gee, if it's attractive enough or conditions are right, they slide into the workforce or they slide out of the workforce. And so that measure of unemployment hasn't been as reliable as we used to think about it when I was in grad school.
Maybe it's a different subject for today. I know unemployment, underemployment, all those kinds of things can be tricky concepts. I guess for purposes of what we're talking about today, though, are we closer to full employment statistically in Missouri or even in the regional Midwest than we were in 2020?
Yes.
Okay. And the reason I ask is I thought I saw, and I honestly don't know exactly where it is here, so correct me if I'm wrong, but I thought I saw one of your discussions in here about, or I think actually it was in your SIR rebuttal, there was criticisms that you don't account for trade-offs, but you're saying, well, we think idle resources will be used. And I understand that can be across a lot, that can be employment, that can be natural resources. There's a lot of different things that can go into that. But as it relates to employment, I mean, are we at the point where in a tight labor market where there's anything else to give without, in terms of available work relative to wage for purposes of what you're looking at in your report?
I think that labor force participation rate is one of those things to look at. When we look at that unemployment statistic, we're looking at people who are actively looking for employment. So there could be people that would move who aren't counted there, aren't in the labor force as counted by government statistics, but given changes, and those changes could be, the ability to work remote, higher wages, a whole host of things could shift people that are not in the labor force into the labor force.
How does the in-plan model, though, I mean, how does it account for that?
So I think what you're saying, as we looked at that, figure 3.2 and the downturn in 2020 is to say, will that give you a false starting point so that you're projecting more jobs because your starting point is 2020? And if you were doing this kind of as a time series analysis, that would be very worrisome. But the way that the in-plan model works is to say that if you invest $1 million in industry segment, or you spend rather, so I'm gonna spend $1 million on wire, steel structures, and things. What is the inter-industry relationship for that? So the structure company is then going to have to buy steel, and then that will increase demand for steel. They're going, so you're looking at all their supply chain impacts. So those interrelationships, it is a snapshot in time as opposed to a time series analysis.
Okay, I guess to ask the ultimate question, and we may have to come back to it, but, I mean, we all understand what we're here for. Companies had you do an analysis. You've given your professional opinion about the economic impact. But is this, do you still believe this is, I mean, because now it's 3 years later from that data, as we sit here today, 3 or 2.5. Do you still believe this is reliably predictive of future outcomes to the best that you can project it in light of the atypical nature of 2020 for the economy in general?
Yes, I do.
So you don't think that the fact that you use 2020, I just want to be clear, you don't think it really makes a difference whether you use 2020 versus 2019 data to your overall conclusions?
I can't say positively for sure because I did not run the 2019 data and do that analysis. But I made that as a professional judgment that it was better to use the 2020 data than the 2019 data in my analysis.
Okay, same, I want to ask you just quickly then on what is going to be red number, page 11 out of 27 for that same DL2 schedule. Figure 3.4 says median household income for the same time scale, 2010 to 2020. Is that, those are nominal numbers, not inflation adjusted numbers, correct?
Yes.
Okay, is that nominal number higher now than it was in 2020 for Missouri?
I don't know for sure. I haven't looked at the 2021 data.
Okay, it was, I mean, by this chart, it was higher in 2018 and even some in 2019 than in 2020, although 2019 is kind of an odd drop there. Is that right?
Yeah, 2019 is lower than 2018.
Okay. Same thing then on figure 3.5, real GDP for Missouri. I mean, that shows a marked drop from 2019 into 2020, correct?
Correct.
But that state of affairs doesn't, you don't think makes, as between 2019 and 2020 data being, well, tell me if you agree. I mean, it's a pretty unique set of facts for 2020, correct?
Correct.
Okay. And so that unique set of economic facts, still same answer, it doesn't make any overall impact on your conclusions for this study?
I still stand by the results of the study.
Okay, but I understand that, I'm not saying your results are inaccurate using 2020 data, but I'm saying the fact that 2020 was very unusual, does that reduce the predictive power of your report forward-looking? Because that's ultimately what their study does, right?
We are making, right, we're making predictions of those economic impacts for future investment.
And so you don't think, though, that the unique circumstances caused a severe drop in Missouri's real GDP in 2020 from the pandemic undercuts at all the accuracy or predictive power of the report forward-looking? Is that right?
No, I feel that this is reliable to the best of our ability to understand.
How does real GDP and maybe it doesn't, because I know this is the preliminary kind of warm-up here, data, but how does it factor into M-Plan? What effect does it have on it?
So, M-Plan is taking all kinds of economic data to feed in, and that's why it's always a year in arrears. So the 2020 data didn't come out till November of 2021. So you get, a full year's lag before you get the next year, data come out, because it's a massive data collection effort. So when we compare this real gross domestic product number, the GDP number is comparable in my results to the output number. So I have three main results I've got: jobs, earnings, and output. Output is a measure like GDP.
Okay, let's look at maybe we'll work at this backwards, and it may help me a little bit. On page 15 of 27 for that Schedule DL2, a chart at the bottom ties to total employment impact, the projections on that. And I want to talk first about the direct construction total employment impact. Let's just take Audrain County, for example. Well, I'll tell you, I grew up literally on the Audrain-Callaway line. Our farm split those lines. And I went to high school in Mexico, which is the county seat. So I'm very familiar with this as a real-world place. Based on your assumptions, I think what it's saying is that you're projecting that it will create 100 jobs over 3 years in Audrain County, correct?
100 jobs over, yes, the 3-year period.
And just so I'm clear, then, in the real world, does that mean that there might be 20 the first year, 50 the second year, and 30 more the last year? Is that how you do how do you get to 100? It's not 100 people working all at once ever, right?
That's correct.
Okay.
It's full-time equivalents, FTEs. So you can normalize for part-time workers.
Right.
And these are short-term effects because it's only during construction.
But then, so annualized, assuming you had even distribution of the number, which I know you may not in the real world, but assuming you did, that's really 33 1/3 jobs in any given year.
That's correct.
It's not 100 jobs all at once.
Yes.
Well, the reason I ask is, high school there has about 200 kids. So if you took every let's just say everybody able-bodied male, it wouldn't be in the modern world, but just for the sake of it being half, they're not all going to step out of high school and theoretically, they wouldn't do this anyway, but let's say that's the workforce you needed. They wouldn't all step out and have a job the day they graduated. It would be 33 1/3 of them would have a job.
That's correct.
And when you talk about that being local, what do you mean by local? It means literally it's going to be people that live in the county?
That was our assumption, that they would be hired locally along the construction route.
And that's the assumption in each of these counties then?
That's correct.
They're going to use a local crew in every one of these counties to build the tower, is the assumption?
Yes.
Is there any reason to believe that's actually how they'll do it?
The work will be done in that county. The question of who does that work within that county, it could be that they hire, local contractors, but that's going to be up to the local practices of the company that's actually doing the construction.
Okay, but this makes a big difference. Doesn't it make a big difference to the underlying economy of the county as to whether they actually hire a local team of people that live there versus have the work done and then they leave? Does that make a difference in your analysis?
That will make a difference.
So if Invenergy hires like a crack team of tower putter-uppers, whatever you call the guys who construct towers, and they come in from, Utah or Texas or wherever, they roll kind of like the wheat harvest all the way across the state, put this thing up, looks great, and they go home. As opposed to they hire this annualized 33 people of literally everybody lives in Audrain County. We could look at their driver's license. Doesn't that make a difference to the underlying analysis for the state's economy?
Depending on where those people live, reside, who gets actually hired on the project, yes.
Okay, to your knowledge, does Invenergy have any binding agreement in place where they would have to use local crews? I mean, it could be a union contract or whatever. I mean, to your knowledge, do they have anything that says, when you do construction in Audrain County, you're gonna hire local people, and you're gonna have that 33.3 every year out there building this thing?
I wouldn't be privy to that information.
And that's
as
fair,
an
but-
outside consultant.
They didn't tell you that's the way they're doing it, though.
They did not, they did not give me any information that they have a union contract as proof that it will be local people in each county.
Right, so they could just as easily, for what you know, use completely out-of-state labor to come in and do this, right?
That was not what I was told that they were going to do when I made the assumptions for the model,
And that's fair. What did they tell you they're gonna do?
that they would hire local,
That was the assumption they had you work on.
yes.
And if that turns out to not be true, does that mean your underlying report would have less predictive power and be less accurate?
So that's going to affect the direct jobs, because those are the effects of those construction workers and others. But you also have to remember an important part, when we're talking about jobs this is really jobs during construction. And to simplify the analysis, this includes all of the expenditures that Invenergy makes up until the point that it's operational. Okay, so you look at construction and you're thinking people climbing the poles, but the cost to Invenergy is going to be attorneys, local land agents that are signing up people. It's going to be, financial people, accounting people. All of that is in, the direct job. So it's.
And I understand all that. Yeah.
33 1/3 is not just saying, oh, that's the guy pouring concrete or
Fair.
stringing the.
Fair enough, and I understand it's a rough proxy for a lot of different jobs, blue collar, white collar, pink collar jobs, all that. I mean, this week we're really zinging the meter on the lawyer side, so at least for Cole County, we're killing it. But we're putting, so as it ties then to, and I understand down the chain even to indirect jobs, induced jobs. I mean, I think I understand generally what you're saying there, but I just want to make sure I understand the assumptions, because we had a lot of talk this week about assumptions, of course, with modeling. How likely are these assumptions to be true? And so, I mean, even for, let's take Audrain, it doesn't, when you take any of these counties, Audrain happens to be first alphabetically, and it's the one I know the best, but, you talk about lawyers and accountants, but you would have to have, let's say that's what it was, you'd have to have those kind of white collar professionals available in Audrain County, or they're not there to hire to begin with, correct?
Right.
And so those jobs don't really inure to the benefit or within Audrain County. They might inure in Boone County down the road where Columbia is, or we got more lawyers there, whatever it may be, but it's not really in Audrain County, right?
Well, so that's one of the beauties of the in-plan modeling software. It does two things for you within the software. So, for example, let's say that there are, just hypothetically, there are no construction workers in the county. We know that that's false. There's always going to be some type of construction workers. But let's assume that there is no industry, there is no, construction firm in that county. In-plan will not assume, it won't force in to say, no, you said you were going to spend money on construction. It knows that there is no construction industry in this county, to be had, and therefore there's no employees, and therefore there's no effect.
Okay, so the bottom line is though, during construction phase, in the real world, when we go forward, if M-Plan's right, we ought to be able to take a 3-year slice of the pie and find 100 people in the real world that were an FTE on this project,
Yes.
right? I mean, I just want to make sure that's what it's telling us. 100 real world people.
So you would be able to measure that only on the direct side, because when you get into the indirect side, those jobs tend to be hidden, right? Because it's wherever you bought the structures from, and things, and we did take care not to say that 100% of where the structure's going to be sourced and all those different items that are there. But those are hidden. You're not going to be able to count individuals
Right,
on a work site.
And I get that, but right now we're just talking about direct, and it may not be on the work site, but it's still in any given year, averaged out, you ought to be able to find between 33 and 34 people that have an FTE. Their FTEs tied directly to the connection of construction of this project.
Yeah, and this again, if we were to look, I did make assumptions here, and it's spread out. I would imagine that if you're doing a construction project, all of the construction in one county, you are going to move. The question as you build the line, the question is, what crew, where are the residences of the crews that are going to be doing the work, and the work takes place in Audrain County?
Here's the reason I'm skeptical, a little skeptical, frankly. In the real world, 35 jobs in that county is a lot of jobs. And you work at Illinois State, you work in the rural Midwest, so in any of these towns in the rural Midwest. And Mexico is a relatively large county seat and was at one time a relatively prosperous small town, kind of big small town from Missouri. Some of these other counties, there's like you go there and you feel like there's just nothing is happening. So in Caldwell County, 122 people, 122 jobs, that's going to annualize out to 40 a year, something like that, if you did it that way. 40 jobs is exceedingly noticeable in that county. So you're going to say during construction, you think you're going to get that kind of kick in local employment where you say, wow, we got all these jobs around here. Where do all these people come from?
I think you're making my case.
No, I'm asking you, is that going to happen? If that happens, we'll be excited.
Again, you go back to, this is over time, this is a very, very large project with very large numbers of investment and things. I could ask the opposite question to say, how can you not hire local people? How can you not help but have a huge economic impact? It does not, I agree with you. I live in a rural county in central Illinois. I see lots of counties that are just as you say, and I say they making this size of an investment is going to have a noticeable impact in the local community.
I guess, Doctor, let me posit then respectfully because you've asked the question. The complaint I think a lot of us hear, for example, a major infrastructure project came through a very similar area, the last pipeline. And then maybe they're wrong, but the constant complaint is, look, they rolled through a team of out-of-state guys. They ate in the cafe for 6 months while they did this. They bought a lot of liquor. If we could have taxed crystal meth in some of these towns, we would have done great because they came and they went. We didn't. But they came, they went, they had minimal impact they bought some gas, they went to our convenience stores, they ate in our cafes, they were here and gone in 6 months, and nobody feels like, this county got any richer, meaningfully richer because of this. So what do you say to that sort of critique? Are they just wrong and that these are sublimated effects, or what's the story on that?
Yeah, I think there are a lot of, as we said, there are a lot of hidden effects that you don't account for. of supplies, materials that are typically purchased locally that also have an effect. And then once this line is built, it's going to be there, it's going to be taxed in the local community, there's going to be services that'll be needed, vegetation management and other things. And so those employment impacts, there are employment impacts during construction, but there are also those operations impacts that, whereas the ones during construction are short-term, the ones during operations are permanent, ongoing jobs.
So I think vegetation management is a great example, actually, to discuss or to ask you about some, maybe not opportunity costs, but just trade-outs, neutral trade-outs. So on the economic activity side for vegetative management, you would input things like, for example, they're buying herbicide at the local, wherever, local co-op at the local Ursuline, what's our farm and home store, a place like that, correct?
Yeah, I
Dr.
can't say for
Loomis,
sure.
can I get you to get a little closer to the microphone?
Sure,
Thank you.
thank you.
Would that be an example, though, of the sort of input that would come in on the input side as a net plus for the economy?
Right, it's purchasing at the local level, and typically we would assume things and materials, especially that would be, hard to transport over a long distance, that
Right.
you'd say, oh, gee, I definitely have to get this locally.
Right, so they go by and they buy their 5-gallon bucket of Roundup to spray the poles, as an example. Now, if the farmer was spraying all that the year before anyway, he was buying from the same place, your study, I think you told Paul, I want to make sure I'm right on this, you're telling us, hey, the company is going to come in and buy herbicide and spray these poles, and that's great, and you reflect that economic activity, but you don't talk about the way that balances off against the fact the farmer might have bought it anyway and done the same thing, correct?
Why is the farmer not buying it?
He's not buying it to spray where the pole is, because he doesn't
Right.
farm there anymore.
But why does the store not buy, why do they not sell 2 5-gallon buckets? They
Well,
sell one to
this
the
is the
vege-
right.
to there and one to the farmer.
I'm sorry. This is the question then about grosses and nets, because I thought what you told Paul was we're showing you what we can definitely quantify and say is going to happen, but we're not attempting to show that in a net sense against any offset or other lost activity on the other side. Is that correct?
We are not taking those losses, but I think your example is a different one than what I understood the questioning was before.
Okay, I guess here's the bottom line question, I think, I guess what I'm trying to figure out because of the inquiry we've got here for our tartan factors. Are any of these counties actually going to be better off economically or richer for having had this happen, for having had this project come through?
Yes.
Okay, and how much richer? I mean, give me a county, give me an example if that's too general of a question, but how much richer?
How do you define rich? If as an economist, this might not satisfy the general public. The broadest measure of economic impact is economic output, and that's the value of goods and services produced within that area. So to give you the example that you did of the herbicide is a perfect example. The amount of economic impact that IMPLAN attributes to that herbicide is only the retail margin of that store that sells it. Let's assume that that's what Monsanto produces Roundup. Let's
Sure,
just say
yeah.
that it does.
They do.
And so the store only makes money on the markup that they make to that herbicide, and the rest of the money, so they receive it from whoever, and then they turn around and they have to buy it wholesale or to a manufacturer, and the economic impact is found where that herbicide is manufactured. Certainly there's a retail margin, that store gets, but that's the only impact to that county is that kind of markup.
Okay. So, and that's fine, but what I'm also then, I'm still asking though about then use A versus use B. So you had 9 acres of farmland that had to be sprayed. So you got 9 acres worth of Roundup somebody's got to buy long before, let's say long before the company showed up. After the fact, you still have 9 acres that have to be sprayed. Now maybe by a different person, but it doesn't require any more Roundup to do it. So what that looks like to a layman, and tell me why I'm wrong, but is at the retail level, and I know it's never going to be perfect. You're right, one guy might end up selling 2 buckets and some people waste it, whatever the case may be, and it's complicated at every individual example. But in general, as to the economic activity of the county, whether the farmer comes in and buys and sprays or the company comes in and sprays, the retail impact, regardless of who buys it, will be identical, correct? For the margin, within implant even, it would be identical, wouldn't it?
Right, I'm still lost on why they don't sell 2 buckets. So
Well,
why
because
is
of
it a zero-sum game and that that bucket that the farmer has, they don't order another bucket and sell 2 buckets?
Why
So
would
now
why
it's
would we?
additive.
Well, normally you spray on a per acre basis. I'm just giving a real world example I know about. You're going to spray on a per acre basis. The farmer has fewer acres to spray. He will buy less Roundup because chemical is expensive. So he used to have 10 acres to spray. Invenergy took an acre, put poles on it. It's now their problem to spray, I guess, to your point.
Yeah,
But it's no longer his problem to spray.
I'm gonna object. I understand that we're trying to work off of hypotheticals here, but we're building in a lot of assumptions that are not in evidence about how vegetation management will be handled. Previously, we dealt with how Greenbelt's going to hire crews, even though there's no evidence and testimony that states that they're going to be from out of state. Yeah, I understand that
Okay,
you're
so
trying to
there's-
make your point, but we've gone pretty far here.
Judge, I guess I will vociferously object to the company trying to shut down legitimate cross-examination that is not, well, A, is not rude or abusive to this witness, B, is completely based in real world examples, and C, is absolutely critical to several of the tartan factors. I understand our crosshair is a little messy because I'm trying to move this along, but these are all legitimate and fair questions. If they have brought this doctor here to tell this commission that there's all sorts of economic upside to this activity, but then when we ask the hard questions about, well, how much net economic activity does it generate, we can't get a straight answer. That's a fair thing for a party in the case to ask and for the commission to hear about. I don't understand the objection. I guess I don't even understand exactly what the question is, the objection is legally, but also as to relevance, if there is a relevance objection in there, these are clearly relevant questions that I'm just doing my best to try to figure out the underlying assumptions in the model.
So it would.
I think what the company, I'm sorry, just one more. I think what the company's asking to do is just take all this at face value and not ask any critical questions about it.
So it's foundation. It's the foundation and the argumentative nature of your question. There isn't any testimony that supports your underlying base assumptions to your questions. So it's a mixture of testimony that you're giving yourself or stuff that's just completely hypothetical, that it's not based in testimony from any other party to this case, or your witness, or any witness that I think is playing the testimony.
All right. I guess whatever the last question was you objected to, do you know what it was?
You were talking about vegetation management.
Okay. I'll lay foundation and do this slow if that's what we want to do, but it's going to take a minute if that's the case, and I think they are fair questions about if they're going to present this as the definitive study that we're all supposed to take to hear about how great the company is, then it's fair to ask about the methodology used to arrive at that conclusion.
Okay. His first objection was assuming facts not in evidence, which I will sustain. Here's the deal. You need to ask your questions, and the witness needs to answer the questions, but we need to have less conversation between you and the witness, okay? So you ask some clear questions, and Dr. Loomis, I'll ask you to give as clear and concise an answer as you can. And if you feel you need to explain, your attorney can get that explanation on redirect. So let's all try to reel it in and get this job done.
I can be more formal, Judge, in my approach, and I will be.
Okay, thank you.
Okay. Let's talk about indirect then. So indirect in your that's a different category. What is indirect according to your testimony? As it applies to employment impact, sorry.
So these would be supply chain impacts that result from materials, equipment, and services that the company purchases.
Okay. And on the indirect side, well, let me ask this first. Let me go back and ask on direct. So direct total employment impact. So you're looking at table 5.1 at the bottom of your page 15 generally. There's all those counties listed there, but I assume you use the same methodology to calculate each of those through IMPLAN, correct?
That's correct.
Okay. So generally for any one of those, did you account for any negative direct effects on employment from the project?
Negative direct effects.
Right.
Could you give me an example of those?
So, for example, well, I guess, is there such a thing as far as a definition that you would work with?
You could net out the direct effects if you think that there's something else that will be, replacing this. But within this framework itself, the company makes an investment. We run that through IMPLAN according to the different calculations, and we get, our jobs impact.
Okay, does the model account, for example, does the model account for economic activity that cannot go on during construction phase? I mean, for example, farming under the line because dozers have torn the dirt up and you can't farm it. Does it account for that?
We heard testimony earlier that there would be crop damage payments compensating for that.
And I'm sorry, and I should have said in the employment context. I mean, you're right, there may be money that flows in for it, but in the employment context. So this is these are jobs that will not be being done because they can't be done. I'm thinking of, for example, let me give you an example on the risk of an objection. I mean, you lose acreage that cannot be farmed because it's been dozed, and so somebody lays off a farmhand because they just don't have the work that year.
Objection.
I know it is, okay.
Objection. There's no foundation that's been laid to suggest that workers will be fired because the grain belt line is it's being constructed.
I think,
Overruled.
Okay.
You can ask that.
okay, so there's ground that can't be farmed because the construction activity is going on. A farmhand gets laid off because there's less to do. That would be a negative direct impact on a direct type job from the construction, or would you consider that to be an indirect effect?
Yeah, it does get confusing on what is a direct and indirect effect. I think it's very clear when you're looking at it from Grain Belt Express. I'm building the line and so forth. It does indeed get messier when you say, where does that farmhand who got laid off in this hypothetical, is that a direct impact? Is it an indirect impact? Where does that fall? We say somebody has lost a job.
I guess more importantly, does IMPLAN account for that sort of phenomenon, which I would posit is entirely realistic. I know they may say there's no foundation, but does IMPLAN account for that, the modeling that you use? Does it account for that sort of phenomenon in terms of giving an overall picture of economic activity?
No, it's not going to know that a farmhand is laid off because crops got bulldozed. There's no way for Implan to do that.
But it does know that somebody got hired, it posits that somebody will be hired to build the project.
Because it sees in an, industry sector, that millions of dollars is being spent, in this sector, and that $1 million of expenditure equates to a certain number of jobs.
Okay, but it doesn't show the loss of dollars being spent then for the converse scenario we just talked about, or any scenario where dollars don't get spent for some alternative reason. Is that right?
Again, I'm not sure that those exist, apart from the hypothetical.
Who designed the Implan methodology? Who actually built it?
So Implan was built out of University of Minnesota. So it was a group of academics who then turned it into a commercial product. I think then it got sold because it has moved to North Carolina. But it's a tool that's used widely in economic development circles. If you went to an economic development local economic development manager, they would say, oh yeah, I know Implan. I use Implan. I use the multipliers out of the Implan model. So it is not specific to energy modeling. It is general economic development software.
Okay, have you ever been personally involved in any sort of post-mortem analysis from an Implan conclusion?
Yes.
And where was that?
That was in Macon County, Illinois.
And what kind of project was it?
It was a wind farm.
And so did you analyze how accurate Implan had been in analyzing the real-world effects?
Yes.
How accurate was it?
Very accurate, given the assumptions. So there was a lawsuit that was given, and so I got records for every worker that worked on the wind farm. I got records from what the company spent after construction on how much did they buy from concrete and rebar and so forth. The one thing I will say, and it goes to your point, is that when I looked at the records, I had concluded that the employment impacts were in Macon County. What I did not account for is that they did indeed hire the local union in Macon County, but Macon County's union is not configured by union or county boundaries. Okay, so they hired local, but then once you turn that over to the union workers, they have seniority rules of who gets to work on one project and so forth. That's completely outside the rules of the company or control of the company. But the overall impacts, as I could measure, and then also going to your point in terms of Implan, I was able to update the year in which the Implan data was done to the year that was when it was actually constructed, and it was very close. I would say within 5%. 10%?
And by 5% of, as to what? As to each statistical category?
I don't recall whether I did, each and every, element, so direct, indirect, and induced, and said each one of those was within 5%. But my recollection was that it was the overall totals for all three categories of jobs, earnings, output were within 5-10% of what I had previously estimated.
And that was for direct impacts, correct?
That was all three, direct, indirect, and induced. But I think my recollection, was that it was on the total impacts, the total employment impacts, all three added together, was within 5 to 10% of what I had predicted it would have been.
Working backwards, how did you definitively measure induced impacts, given how diffuse they are?
Again, I relied on in-plan, but more recent data.
No, I'm not talking about the modeling forward-looking. I'm saying in your postmortem. I mean, what I'm talking about is a postmortem. Did you go back and survey in the real world and find out, yeah, here's 12 jobs that got, whatever the number was, that got kicked off as induced activity?
Right.
Did you go find those people and interview them and find out?
No.
Is it-
I again relied on in-plan's estimate of the induced impacts.
Okay, so this is what I'm asking about, though. So in that project, you used implant. Tell me if this is what you did. Did you use implant to make a forward-looking prediction in that context? Or were you only hired in on the back end to say, hey, what happened with this project?
No, I was hired to do a study for permission to permit the wind farm, and that was entered into evidence for the county permitting hearing. So I did it in advance.
Okay, and this is what I'm asking, though. So you did a study prospectively, forward-looking, said, here's what I think is going to happen, like you have today, correct? Okay, and then you went back years later to see whether you were right?
Right, I got those records of actual expenditures, who actually worked on the project, and so forth.
Okay, so, and I get direct. Direct may be easier because you can figure out who worked on the project. But I'm curious about indirect and induced. Because induced is the most attenuated of the effects, correct?
Right.
Okay. It's kind of tertiary effects kicked off by economic activity. To be clear, I'm not doubting those happen, that in general those things exist. But I'm asking you, how did you go back and measure to see if you were right to the induced effects in that context?
Right, so what I was able to verify was, here are the people who worked on the project, here's how much they earned. So I know the direct numbers with certainty for that. I then have for the indirect impacts, I know how much they spent, and more importantly, where they spent it. So one of the big things would be, did they buy local, or did they buy, out of county, out of state?
How did you know that? And I'm sorry, how did you know that for the direct impact folks, where they spent their money?
No, I'm saying the company spent money on concrete and rebar and those things.
So just so I'm clear, then, this is not knock-on effects from workers spending their money locally, or is it?
I'm getting to that.
Okay, I'm sorry.
So in order to measure the induced impacts, which you write is derivative to say, now people have more income in the economy, so they make normal household purchases. They buy groceries, they go to the movie theater, they eat out, and so forth. You're right, I can't measure those. I can't go out and survey and say, aha, you did this because it was this construction worker that was working on this project, and they bought groceries at the local grocery store, and they had to add additional cashier because of that. So I did rely on in-plan to calculate my induced impacts.
Okay, so, but I guess the problem there, though, is if in-plan has flaws in its, because all economic models have some small flaw, correct?
They're not going to be absolute certainty. It's predictive.
Right, and and I'm not trying to hold you to that. I think we all understand that. But if it had flaws, it's supposed to be predictive, but you never calibrate the machine using backward-looking data, then how do you know you're not just getting feedback loops of error within the model?
Because you have to true up the model to government statistics. They have checks and balances in which everything has to add up.
But that's what I'm asking, though, especially in induced effects, where you're telling me it's really not measurable in the real world. and you just use Implan to look backward at what Implan said it would do, won't it always tell you that it's the same data?
Well, in the aggregate, you know what employment is at the grocery store and what is in the, restaurants and so forth. So you have the ability to add those all up, and things. What Implan is adding is those inter-industry relationships. You know that they have to sum up at the end of the day.
Okay, and I promise, getting close to wrapping this up. So, just so I'm clear then on these conclusions, I think you've already said, in the employment context, after 3 years of construction, we should be able to go any one of these counties and find that annualized number of people saying, yep, I was an FTE connected to some kind of work in this project. I know it could be construction, accounting, whatever. We should be able to find those people, right?
Yes.
Okay. And same thing then with operations, the next category. We ought to be able to go any one of these counties and find, I mean, a lot of these are fractional, but the 0.3 FTE that worked in that county and probably 3 others in any given year for the company, that person should exist. We ought to be able to find indirect and induced employees down the chain from those from this project, correct?
Given the assumption of the model, correct.
Okay.
That's right.
And Dr. Loomis, again, if you could get close to the microphone, and Mr. Hayden, if you really could get close to the end.
Oh, I thought you were going to say get close to the microphone. I thought I was
No.
loud enough. I figured that
you're-
wasn't a problem.
Yeah. I just, if you can rein it in, we've gotten pretty far down the rabbit hole.
Judge, I understand. I think they're going to rely heavily on this data, though, on these analyses as it relates to Factor 5 and the Tartan test, and so I will try to wrap it up. But same thing then on total earnings impact. I mean, we should be able to go to one of these counties and find, this is what I wanted to ask. So, for example, let's just take Audrain again. You've got a number there on the top of your page 17 or 27. Direct construction effects, you predict in Audrain County, $22 million, almost $22.8 million, just under. Do you see that?
Yes.
Okay. We should be able to go find where $22.8 million, almost 22.7, got spent in Audrain County for the construction of this project, correct?
Yes.
Okay. And if we can't find that, if that doesn't happen, this model will have failed. And so I mean, if we're not close, this model will have failed in some sense, correct?
Yes.
And does that happen sometimes with Implan, to your knowledge?
I've only done that one case of the postmortem and looked back. And again, it was because I had lots of data and records that I was able to do that.
Let me ask that a different way, because you work in this sphere. Have you ever read any peer-reviewed academic papers that would outline other, or a case, not, I shouldn't say other, because you're saying your case doesn't show a failure, but cases that would show failures of the Implan model to accurately predict economic conditions?
Actually, to the contrary, I've published articles on wind and solar that have passed peer-reviewed publications that have relied on Implan to predict.
But that's not my question. What I'm saying is, have you ever read, just like in medical studies, they say, hey, we had a patient come in and die, and here's why. Have you ever read one where an academic has said, hey, we used Implan, and this was an absolute wreck, and here's why, or maybe we don't know why, but the model failed to accurately predict generally what was going to happen in terms of economic conditions? Have you read a paper that talked about that ever from any other academic in your field?
To the contrary, there is a paper, and I'm not sure if I cite it in our study here.
Doctor, I'm sorry, because they're hustling me along. I understand there may be papers that say it works, but that's not my question. My question is, have you read a paper anywhere that would talk about where Implan failed? If the answer is no, fine, but I mean, have you ever read any papers like that? Does anything like that exist?
I'm sorry, Judge DePel. I need to object. Dr. Loomis needs to be able to answer the question. He was looking for a paper that he wants to cite to as part of his response. I think he has a right to do that.
Well, then, Judge, I guess what I would ask is that you would direct the witness to make a responsive answer to my question. I don't think it was, I'm qualifying an answer. My question was, is there a paper that says this? And he was saying to the contrary, there's one that says it works, and that's fine. And they can ask him that on redirect. But I'm asking about, is there one that says it failed? And I think it's a fair question.
I agree. The witness can answer the question, yes, no, I don't know. I need to look it up.
No, I'm not aware of a peer-reviewed publication that it is a case study where in-plan failed.
So to your knowledge, in-plan works every time?
That's not what I said.
Okay.
I said, your question was, is there a peer-reviewed publication in which in-plan failed? And I said, no. What I was trying to say before was that there are papers that look at multiple methods to estimate economic impacts. And the conclusion of that paper that I was going to mention is that in-plan is one of the best ways to do the estimation. It's using input-output methodology that in-plan is based on.
Are there methodologies that are better?
That paper, my recollection of the paper, and it's been a while,
Sure.
is that input-output analysis is the best predictor.
That's all I had for now, Judge.
Thank you. Is, Mr. Hollander had to leave. Is there anything, Ms. Stimmy? No questions. Associated Industries?
A couple of very quick ones, I promise.
I've heard promises before here.
Trust me, I'm not replicating what happened on the front row. Good afternoon, Dr. Loomis.
Good afternoon.
I just have a couple of very quick questions. In the study that you did, you were not asked to calculate whether new industries would locate in Missouri due to the project. Is that correct?
That's correct.
If new industries were to be studied and new industries were to relocate, would that have a positive economic benefit to the state?
Yes, to the extent, as I mentioned before, that an industry doesn't exist in a county, in-plan would assign, even though there was expenditure, they would assign a zero value for that. If that industry were to move in, then it would add to the economic impacts that are in this study.
And I believe you testified before, and I believe your CV indicates that you've done a lot of writing and research in the areas of utility regulation, et cetera, and economic impact thereof, right?
Correct.
And a better, stronger electric distribution system and transmission system serves benefits to the industry. Is that correct? Industry in general.
Industry, not the energy industry, but you just mean businesses.
Yes.
Yes.
And you were not asked to quantify those impacts, but they would be positive for a better transmission system, correct?
That's correct.
Similarly, if existing businesses or industries in the footprint were to expand, you were not asked to evaluate that, were you?
No.
But those would have positive economic effects, correct?
Yes.
And if there were existing businesses or industries that might leave because of a weak transmission system and chose to stay, you weren't asked to study that, were you?
No.
But those would have positive economic effects, wouldn't they?
Yes, they would.
So ultimately, each of those items, whether there were new industries that moved in, existing industries that expanded, or existing industries that did not leave, they would all have additional positive economic benefits to the state of Missouri, correct?
That's correct.
No further questions, Judge.
Thank you. Are there any questions from the commissioners? Mr. Chairman?
Thank you, Judge.
Try to be quick.
Just wanted to clarify. You had testified that the economic impact numbers that you assumed in your analysis, you assumed all jobs from the project would be Missouri residents.
All the jobs, direct jobs during construction. That's correct.
All right, thank you.
Any other commission questions? And commissioners online, just speak up if you have questions.
No questions, Judge. This is Commissioner Kokemeyer.
Thank you, Commissioner. All right. Is there any further cross-examination based on the chairman's question? And I'll just throw it out to the group. Not seeing any. Is there redirect?
Yes, Your Honor. Dr. Loomis, do you remember during Mr. Hayden's questioning regarding M-Plan's peer review process, you were not given the opportunity to respond to find the cited article that spoke about M-Plan's strengths relative to other models? Would you like to find that to supplement or to complete the record on that point?
It's by, not sure if I'm pronouncing it right, grilled cheese, and I do not see it in my list of references in the report. So I don't think it's in the record.
Okay.
Grilleches, but that's from memory. Subject to check.
Thank you. Mr. Hayden, do you remember a line of questioning where Mr. Hayden asked you, I believe he cited the table 5.3, which is on page 17 of 27 of DL2. I don't know the exact number that he cited to, but for example, I think let's take the construction direct for Audrain County. It lists 22,793,545. I believe Mr. Hayden asked you the question, if we can't find that exact number in the county, has the in-plan model failed?
I'm going to object. I think that misstates the question because I don't think I ever said that exact number ever.
I'll make it a more general question, if that's helpful.
Fair enough.
So Mr. Hayden pointed to your numbers and said, if we can't find that number, does that mean that the in-plan model is a failure? Is it fair to say that in any economic analysis, there will be a margin of error?
Yes,
And having some margin of error does not necessarily make a model a failure. Is that correct?
that's right.
Okay. And there's been a lot of talk about gross economic analysis versus net economic analysis. And I believe Mr. Hayden and Mr. Agathan have pointed to several examples where they believe there could be negative economic outputs. Is it fair to say that you also didn't consider a number of positive economic outputs?
That's correct.
Okay. And I know that you've handled just a few, but is it true that your report does not include a number of economic benefits that were addressed in Mr. Repsher's analysis?
That's correct.
Is it also true that your report wouldn't contemplate the benefits that are found in Mr. Munkin's analysis of the project?
That was the Guidehouse report?
Converge, the national security report.
That's right. I did not include those benefits.
And the same would be true about the Guidehouse report's benefits?
Yes.
Okay. And so those would all, to the extent that they created economic benefits, those would not be reflected in the numbers that you have in, say, table 5.3.
That's correct.
Okay, thank you. Is the measurement of purely gross impacts consistent with industry standards?
Yes.
Okay.
The answer's here. I will back off my objection. I guess got to be faster.
And I know Mr. Hayden was concerned that there are some economic earnings results or labor that would be duplicative of existing labor, but is there sufficient reason for you to understand and support the assumption that many of the economic inputs and job growth created by this project are non-duplicative of existing resources?
Yes.
Okay. Do you remember, I think Mr. Agathan asked you a series of questions about deductions from compensation received by workers?
Yes.
And I believe that he mentioned federal income tax and social security taxes.
Correct.
That would be true of any lawful profession, correct? That there would be that amount taken out of someone's pay.
That's right.
Okay. Thank you, Dr. Loomis. That's all I have.
Thank you, Dr. Loomis. I believe that concludes your testimony, and you may be excused. And that brings us to 5:05, and I think it's a good place before we begin with staff's first witness to take a short break. Let's try to take just a 10-minute break and come back at 5:15. Thank you. We can go ahead and go back on the record. All right, we're back on the record. And Ms. Eubanks has already taken the stand, so we'll begin with staff's witnesses. I will ask her to raise her right hand. Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. Mr. Pringle, you may go ahead.
Thank you, Judge. Ms. Eubanks, would you please state and spell your name for the record?
Claire Eubanks, CLAIRE-EUBANKS.
Thank you, Ms. Eubanks. And by who are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as the manager of the Engineering Analysis Department.
And did you contribute to staff's report in this case, which has been previously marked as Exhibit 109?
I did.
Did you submit rebuttal testimony in this case, which has been previously marked as Exhibit 102?
Yes.
At this time, do you have any corrections to make to the staff report or your rebuttal testimony?
I do. It's the same change throughout. So I'll start with the staff report. This is on page 10, at the very bottom of the page. It's to strike the words "any all." So the last line would read, "into easement agreements with Missouri landowners." And then similarly, in my testimony, on page 8, line 20, the words "any all" would be struck, and it should read, "to incorporate House Bill 205 into easement agreements with Missouri landowners."
Sorry, I'm catching up. I'm still on page 10. Was it page 10 of the
Staff report?
Yes.
Which is marked as Exhibit 109.
And sorry, where on that page was the modification?
Towards the bottom. Pretty much look at this language.
Page 8.
And I'm looking at the revised staff report. So if it's different page numbering, that might be.
Found it.
Thank you.
Okay, and that was, did you get both of those changes,
So
Mr. Schulte?
yeah, I've found the place on the page. So what, sorry, could you say the modification again?
I'm just deleting the words "any all,"
Got it.
and it's going to be the same change throughout. It's just in three spots.
Thank you.
Oh, I only got 2 spots myself. Okay.
So one spot is in the revised staff report on page 10, page 8, line 20, and then finally page 18, line 16. The last 2 are my rebuttal testimony.
Page 18, line 16.
Yes.
Somehow I missed that one. Okay, Mr. Pringle, I think we're all caught up.
Thank you, Ms. Eubanks. And besides those corrections, at this time, if I asked you the same questions today within your rebuttal testimony, would your answers be the same?
Yes.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
Thank you, Ms. Eubanks. At this time, I offer into the record Exhibits 102, 102HC, and 102HC-C.
And 109, or are you holding that till later?
Mr. Stallman sponsored that report. He'll be kind in with him.
Okay. Would there be any objection to Exhibit 102, which has a highly confidential version and a highly confidential competitive version, which I know not everyone has access to? Are there any objections? Seeing none, I will admit those.
Thank you, Judge. And Ms. Eubanks, with those corrections we discussed earlier, what is staff's current position regarding the HB 2005 recommendation?
Staff's current position is currently provided no further changes in other positions. Staff recommends a condition that, let me make sure I'm reading it correctly, that Greenbelt Express file with the commission revised landowner protocols to clearly articulate the compensation package offered to landowners by phase and/or line type as modified pursuant to the commission's decision on issue 2.
Thank you, Ms. Eubanks. And just to be clear, at this time, staff is not recommending the implementation of all of HB 2005 at this time, correct?
Not without, I guess that's based on the full entirety of staff's recommended conditions. Yes.
All right. Thank you, Ms. Eubanks. Judge DePel, at this time, I tender the witness for cross-examination.
And just to make things clear, were those the revised position that Ms. Eubanks is testifying to, those were put in staff's revised position statement?
Yes, that was filed with our pre-filed exhibit list, correct.
Okay, thank you. Is there any cross-examination from MLA?
No, Judge.
From the ag associations?
Sorry, our mic's off. No, Your Honor.
That's fine. Ms. Stimmy? No questions. Public counsel?
Thank you, no.
Associated's attorney asked to be excused for the rest of the day and waived cross. Sierra Club?
No, thank you.
Renew Missouri?
No, thank you.
Clean Grid Alliance?
No cross, thank you.
MEC?
Yes, Your Honor, briefly, but I believe we'll be touching on HC materials, and I'd be glad to hold off so that if others, I guess Greenbelt comes after me, if they have cross that's on that, I'd be glad to wait so that we just do that one time through, whatever the court prefers.
Oh, I think that's a good idea. If Greenbelt thinks it might have cross that touches on any HC materials that MEC can hear.
We don't have any planned cross that would touch on HC materials.
Okay. Let me check while we're on that subject to see if I knew of any questions that might touch on that. I don't think so. I think it's just going to be MEC. So we could just go ahead and go in an in-camera session now if everyone's prepared for that. And this is just highly confidential, correct?
Depending on Ms. Eubanks' answers, I will start with highly confidential, but it could go into HCC depending on her answers. But I hope we just stay with highly confidential. I will assure the court that if we get into HCC, it's MEC's HCC
Right.
material, so that'll be no problem.
Okay. So I will ask anyone in the room who's not authorized to hear the highly confidential information to please leave the room, and I will send someone out upon the conclusion for you all to return. go back on the public. There we go. Okay. And was that the end then of your cross-examination? Or did
Yes,
you
it
have
was.
more?
Thank you,
Okay.
Judge.
All right. Is there cross-examination from Greenbelt?
Yes, please. Good afternoon or evening, Ms. Eubanks.
Good evening.
Could you please turn to page 3 of your rebuttal testimony?
Yes.
And beginning at line 20, the question there reads, does staff support the modification to allow for construction on easements prior to the entire project being fully financed? Did I read that question correctly?
Yes.
And is that modification also referred to as phasing?
It is.
And then at line 22, your answer is no, not at this time.
That's
Did I-
correct.
Is that still staff's position?
Yes.
Then later in that answer, and I'm turning now to page 4, line 4, there's a sentence that states, further, Illinois has recently approved the GBE portion of the project in Illinois. Did I read that correctly?
You did?
And again, this is in the answer to the question regarding staff's position on phasing. So is the intended implication there that because Grainbelt Express has received a certificate in Illinois, it should be able to finance both phases on the same timeline?
I would defer any financing questions to Dr. Juan.
What is the intent of that statement that Illinois has recently approved the Grainbelt Express portion of the project in Illinois?
So in the transcript from the 2016 case, my understanding was there was a line of questioning about what would prevent Grainbelt from actually constructing the line. It dealt with financing, construction costs, and whether there would be customers to purchase from the line.
Okay.
So in that discussion, there was also mention of regulatory approvals. So just was really just for clarification that other regulatory approvals have been satisfied.
Did that
State commissions, to be clear.
Did that discussion include consideration of the land acquisition process in Illinois?
I don't recall that specifically.
Okay. Do you recall if that discussion, and again, this is what was a discussion in the transcript in 2016?
Yes.
Was it the 2016, so the 2016 docket was adjudicated before the PSC and then went up on appeal and then was remanded. Are you aware of whether this portion of the transcript was in the first part of the proceeding or in the remand part of the
I
proceeding?
believe it was in the remand portion of the proceeding. Subject to check.
Okay. One second. We're just taking, I see that you have a citation footnote 3 on page 3 of your rebuttal testimony refers to the 3 major issues it may have, that Grainbelt may have with constructing the line. And it cites to transcript volume 10, pages 259 through 261. Is that an accurate reading of your transcript and of your testimony?
That is what footnote 3 says, yes.
Okay, and that was the portion of the transcript that you were referring to just in the previous exchange?
I believe it's in that portion of the transcript. Whether it might be off a page or two, I don't recall, but.
Okay. We were able to locate volume 10. It looks like it's from March 20th, 2017. Okay, I can move on. I just wanted to get that clear in my head. Do you recall if that part of the transcript from that you cited in your testimony, did it include a consideration of the time for completing detailed engineering and design for the project after receiving state regulatory approvals?
I don't recall that in that portion. I might need to look at it to recall.
Okay. And outside of whether the transcript from 2017 addressed those issues, did you consider those issues as part of your preparation for this current case and this rebuttal testimony?
Can you clarify your question?
Sure. In preparing for staff's position on phasing in this case, did you consider the land acquisition process in Illinois and the steps required for that and the timing of that process?
In Illinois?
Yes.
So I'm not the only witness that is supporting staff's position on phasing. So clarifying that. But no, I personally did not know.
Okay. In preparing your rebuttal testimony and in your portion of the input on staff's position on phasing, did you consider the timelines for completing detailed engineering and design for the portion of the project in Illinois?
I did not.
Okay. And in preparing your rebuttal testimony and for your input on staff's position regarding phasing in this proceeding, did you consider the status of the PJM interconnection request?
Staff, I believe, considered the PJM interconnection request, but that is in Sean Lange's testimony.
Okay. And just one more. In preparing your rebuttal testimony and for your portion of the input on staff's position on phasing in this proceeding, did you consider the process for obtaining environmental permits in Illinois?
In Illinois, no.
Okay. Those are all the questions that I have. Thank you.
Thank you.
Thank you. Are there commission questions for Ms. Eubanks? Mr. Chairman?
Thank you, Judge. I know in your Sir rebuttal testimony you had some concerns about black start and long generator lead lines that I believe the company's witness Rodriguez had responded to. Did his response mitigate your questions, or is there still concerns or issues or information that you are seeking?
So staff has a recommended condition that we are provided notice essentially if the line gets designated as a black start resource. There was some detailed information about what other steps need to be taken, and that's in a data request that's attached to my rebuttal testimony, if the commission's interested. So staff's recommended condition alleviates the concerns. It was more the wanting to make sure the commission was aware that just because something is designed to do something, it doesn't necessarily mean all the steps are in the place that will actually come to fruition. And about the long generator lead line, I think that was maybe a phrase in my testimony. Staff has discussed the various studies from the RTOs, and that's in Sean Lange's testimony. So I will say that staff's material change definition discusses injection withdrawal rights. So that also alleviates staff's concern. Yeah.
Okay. I think it was your rebuttal testimony where you were talking, I think it got brought up on the Guidehouse report. So by reading that, is staff's basic objection to the Guidehouse report is that the benefits are only materialize if the entire, both phase 1 and phase 2 are completed?
And that the line is fully subscribed and that there are enough generators on the front end to use the line. Yeah.
You also stated that one of the concerns with the study was that it assumed bidirectional flow with MISO, and I think maybe it was even talking about the winter storm and how much it could have alleviated, but trying to remember the testimony, I believe it was that you stated that there was only an agreement with MISO for one directional flows, so those benefits wouldn't have been there. Assuming that the company does go to MISO and inks an agreement for bidirectional flow, do you believe that those savings or values in the Guidehouse study would materialize? And do you believe that any of the value that the line could have given Missouri ratepayers because of Storm Uri would have or were actually a real value that could have alleviated cost?
So there's quite a bit there. So I think my understanding is there's incremental investment and studies that would need to be done for SPP, so actually the front end of the line. And I think Mr. Rodriguez talked about this a little bit yesterday, how it would actually work. And he also explained some of the studies, and Mr. Laney can speak more to that also. So that was one part of your question. And I think another part was,
Okay, so let me rephrase the question.
sorry.
Did staff discount the guidehouse study because there was only one, an agreement with MISO for one directional flow? Or does staff believe that if bidirectional flow was on the line, would the study have more validity in staff's mind?
I think staff took issue with more the quantification of the value. I think our overall recommendation regarding the guidehouse study was, not really to rely on it for findings of fact related to need. So to the extent there are benefits from interregional transmission projects, staff doesn't dispute that. Does that answer your question?
Yeah, I wanted to see if it was being discounted because, well, the agreement isn't there, or are you questioning the validity of if there was an agreement with MISO would there be value? And I think you answered that, for at least in my head. Walk me through your thoughts on, I believe the Guidehouse study talked about, or maybe it was somewhere else, the line being able to add capacity that MISO is short, but staff seemed to discount whether or not that was a reality. Am I remembering staff's position correctly?
Yeah, so I presented a table of MISO accredited values for wind and solar and other resources for capacity. And, I think my understanding is there's going to be quite a bit large addition of wind and solar to make up for, the lower accredited capacity. So I think staff's was basically saying, solar, storage, thermal, that, or, quite a bit of wind and solar, just as a clarification, yeah.
So basically, it's, if it was a gas-powered plant, the capacity could be there, you just, through the discounted amount of capacity is given to wind and solar, staff views it as not really being able to help.
You just need a lot more of it.
A lot more,
Right.
so won't,
Right.
okay. I know we talked about the accreditation values maybe on Monday, and of the different, we talked about when we talked about, but storage. How does staff view the amount of capacity that could be added to help MISO if it was a storage versus gas versus wind versus solar?
I don't think staff has presented any specific numbers on that. We would have to look at a project, I think, to form some more thoughtful opinions.
Does staff
Apologize.
believe that storage adds more capacity value than a wind or a solar?
Well, you're able to move, store it and use the power when you need it. There's
it's more
there's benefits to
dispatchable.
it, right?
That's all I had for this witness. Thank you, Judge.
Thank you. Are there other commission questions? All right. I've got a few here. In response to Dr. Juan's proposed revisions to Grainbelt's amended financing conditions, Grainbelt's witness Rolanda Shine proposed a definition of installed transmission facilities. Does staff have an opinion on that proposed definition as it relates to the financing conditions? Is that
Staff does not oppose that addition.
okay? Based on the review of Grainbelt's proposed modifications to the condition in the landowner protocol, it appears that Grainbelt is delineating different conditions for the existing line and the Tiger connector. Is that staff's understanding?
Yes.
And are staff's proposed amendments to the conditions intended to be both the existing line and the Tiger connector?
So staff has changed its position and is no longer recommending a specific one way or the other. We just want the landowner protocols to be clear to landowners of if it's for phase one, if it's for the Tiger connector, if it's for phase two, if it's based on the date of the commission order.
Okay. My questions were written before you changed your position.
Understandable.
In your rebuttal on pages 8 through 10, you discuss Grainbelt's proposed changes to the landowner compensation package.
Yes.
And given changes and everything, have your concerns been addressed with regard to that?
So staff has changed its position, and so the concerns on modification to ordered paragraph 8, we're just requesting that those changes be made to the landowner protocols and be filed with the commission
Okay.
as to whatever the commission decides on that issue.
And then a similar question was asked of Mr. Chandler. Based on the elimination of the structure payments for landowners along the Tiger connection or connector, are you able to envision a scenario in which a landowner might be worse off in terms of compensation?
So the payment, as I understand it, would take the size of the easement area, the 150% value, and then the land value. So it's kind of a moving target, if you will. I do think that smaller parcels that would have a structure on it would likely not see the same benefit from the 150% only versus the 110% in the structure payment.
And then I'm gonna switch directions a little bit. In Mr. Petty's direct testimony that was adopted, He cites at page 9 to the Guidehouse report saying, estimates that the project will mitigate additional reliability-driven generation capacity investments of approximately $526 million per year and approximately $7.6 billion for the life of the project. And then it further breaks down regional benefits in Table 9. Did you find those figures to be reasonable estimate of the project benefits?
I actually don't have a copy of the
Oh,
Guidehouse
I
study with me.
apologize.
See if Travis has it. What was the table? I'm sorry.
His testimony at page 9 cites to a table 9 of the Guidehouse report. Saying that additional reliability-driven generation capacity investments that it will mitigate additional reliability-driven generation capacity investments. That's quite a mouthful. Of approximately $526 million per year and approximately $7.6 billion for life of the project.
If I could real quick, just I have a copy of the Guidehouse study if.
Yeah.
Thank you. You said page 9 or table 9? I'm sorry.
It's page 9 of his direct testimony where it mentions or refers to table 9 of the report. I don't know what page table 9 is on. I mean, did you do any analysis of those estimates? To be honest, I don't have the Guidehouse report in front of me either.
Okay, so I'll explain what Table 9 is. It is a project potential resource adequacy benefit is what it's labeled. It has several point of interconnections, the benefiting system, the amount of injection, the cost of new entry or the cone, and then the calculated benefit related to that. And I don't recall specifically addressing that table in my rebuttal testimony.
And just reviewing it there, you don't have an opinion at this point. I mean, if you haven't had a chance to analyze it, I don't want you to give me an opinion just to give me an opinion.
I don't have an opinion at the moment, no.
Okay. A number of reliability and resiliency benefits were identified in that Guidehouse report. In terms of the benefits of avoided loss load, would you say the benefit and/or the value of the avoided loss load is higher, given the revised proposal incorporates 2 injection points rather than 1.
Could you repeat your question?
Yeah, it was kind of long. A number of reliability and resiliency benefits were identified in the Guidehouse report. In terms of of the benefits of avoided loss load, would you say the benefit or value of the avoided loss load is higher, given the revised proposal incorporates 2 injection points rather than 1?
I don't recall there being that type of calculation in the Guidehouse study. And I could be
Okay.
forgetting
and-
something, but
And then with regard to my previous question about the estimate of the project benefits in that table 9, is there another staff witness that I should ask that question to that did review that?
I reviewed it. I chose not to address it.
Right, okay.
Right. So
So there's not another?
no,
Okay, thank you.
not to my knowledge.
Okay, thank you. Okay, I think that's all the questions that the commission had, and myself. Is there further cross-examination based on questions from the bench from MLA,
No, Your Honor.
from the agriculture associations?
No, Your Honor. Sorry, mic's off.
Ms. Stimmy? No questions. Public counsel?
Thank you, no.
Sierra Club?
No, thank you.
Renew Missouri?
No, thank you.
Clean Grid Alliance?
No, thank you.
MEC?
No, Your Honor, thank you.
Greenbelt?
Just one, I think. You, in responding to some questions from Chair Roop, you referenced the staff proposed condition regarding the definition of material change.
I did.
And you referenced the threshold of a 100 megawatt change in injection or withdrawal.
I don't think I specified 100 megawatts, but I did reference the injection and withdrawal. Yes.
Okay. And is staff's recommendation a 100 megawatt threshold change in those, in an injection or withdrawal?
Let me look at that's not in the position statement. I would defer to staff witness Michael Stallman.
Okay, thank you.
That's all?
Yeah, I just wanted to make sure, since she had mentioned that condition, I wanted to make sure she wasn't the right witness to ask questions about that condition.
Okay. Is there any redirect from staff?
Brief, Judge. And Ms. Eubanks, when it came to your input into staff's position regarding the opposition of phasing, what did you consider?
So I went back and looked at what the commission had decided previously in the report and order on financing, that condition, and read the transcript and considered the impact of House Bill 205 because that was part of what I was looking at, and that those are the things that I took into consideration primarily, as well as input from other staff members.
And just for the record, by House Bill 205, you do mean House Bill 2005.
I do, yes.
Thank you very much, Ms. Eubanks. Nothing further, Judge.
Okay, thank you, Ms. Eubanks. You may step down. You be excused. No, and I was about to ask if Dr. Juan was available, and he's coming up the aisle, so answers that question. It's on the hook now. Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. If you could spell your name for the court reporter, please.
Sungjun Won, Seoung space Joun, last name Won.
Okay, Mr. Pringle, go ahead.
Thank you, Judge. Good evening, Dr. Juan. By who are you employed and in what capacity?
I work for Missouri Public Service Commission as the manager of the Financial Analysis Department.
And did you contribute to staff's report in this case, which has been previously marked as Exhibit 109?
Yes,
Did you also submit rebuttal testimony in this case, which has been previously marked as Exhibit 108?
yes,
At this time, do you have any corrections to make to the staff report or your rebuttal testimony?
no,
If I asked you the same questions today within your rebuttal testimony, would your answers be the same?
yes,
Are those answers true and correct to the best of your knowledge and belief?
yes.
Thank you, Dr. Juan. At this time, I offer Exhibit 108 and 108HC into the record.
Would there be any objection to Exhibit 108 and 108HC? Seeing none, I will admit those.
Thank you, Judge. At this time, I tender the witness for cross-examination.
Is there any cross-examination from MLA?
No, Your Honor, thank you.
Agriculture associations?
None, Your Honor.
Ms. Stimming? Public counsel?
Thank you, no.
Sierra Club?
No, thank you.
Renew Missouri?
No, thank you.
Clean Grid Alliance?
No questions, thank you.
MEC?
No, Your Honor, thank you.
Grainbelt?
Good evening, Dr. Juan.
Good evening.
Were you in the room for Ms. Eubanks' testimony today?
I don't have it.
No, I'm sorry, were you in the room for her
Oh, yes.
live testimony?
Yes.
Okay. She referenced your input regarding staff's position on phasing. So I wanted to ask you a couple questions about considerations that staff took into account with regard to its position on phasing. In your role, in your input on staff's position, did you consider the land acquisition process in Illinois and the timing of that process?
No,
What about the timelines for completing detailed engineering and design for the project in Illinois?
I did not.
Did you consider the status of the PJM interconnection requests?
No,
And did you consider the need for obtaining environmental permits or the timelines associated with those in
No.
Illinois? Okay. Those are all the questions I have. Thank you.
Thank you. Are there commission questions for Dr. Juan? I have just a couple. Did staff review Grainbelt's pro forma information for Phase 1 as submitted in Rolanda Shine's rebuttal, Schedule RS3?
yes, but my expertise limited to the financial ability. Most of that ability. My understanding is those schedule is mainly focused on economic feasibility issue.
Okay. Did your limited review, did you have any concerns on your limited review?
I have concerns, but I would like to refer to the staff witness Michael Storman to answer that question.
Michael Stark.
Storman.
I can't say it either, so. And he's gonna be our last staff witness today, so. Okay, or not today. Our last staff witness. In response to your proposed revisions to grain belts, let me start over. In response to your proposed revisions to grain belts amended financing conditions, and if this has changed, let me know. Grain belts witness Rolanda Shine proposed a definition of installed transmission facilities. Does staff have an opinion about that proposed definition as it relates to the financing?
So actually, that definition is not really matter for the financial ability. So, in my perspective, there is no concern about the definition.
Okay. Okay. That's all the questions I had. Is there any additional cross-examination based on questions from the bench? MLA,
Oh, Your Honor.
agriculture associations, not seeing anybody. Ms. Stimmy? No questions. Public counsel,
Thank you, no.
Associated, the Associated's left the building. Sierra Club,
No, thank you.
Renew Missouri,
No, thank you.
Clean Grid Alliance, MEC,
No, Your Honor, thank you.
Greenbelt.
No further questions, thank you.
Any redirect from staff?
Brief, Judge, thank you. Dr. Juan, questions from the bench. You brought up economic feasibility. What is your definition of economic feasibility?
The definition of economic feasibility is focus on the comparison of investment to how. Yes, investment and return.
And does that have any difference, in your opinion, regarding financial feasibility?
Financial feasibility, you can interchangeably use it.
And then, just for clarification, can you also define financial viability?
So financial viability has very similar definition to economic feasibility, but that is more focused on the financial statement analysis. For example, coverage ratio. Coverage. Financial statement analysis.
And,
So,
sorry.
when you conduct economic feasibility study, investment amount is kind of treated as a given number, and then calculating the cash flow analysis and compare net present value, so that project is profitable or not. That is determined during the economic feasibility study. So, but the financial liability is focused on the entity can be survived or not. So that analysis considering the revenue streams and expense streams. So, and then using the financial statement information, so several financial ratios is calculated and then how focus on the default possibility. So calculate and evaluate about the that project is survive or not.
And do you recall, did you or staff use the term financial viability in our report or your rebuttal?
So step did not use financial liability. That is not Tartan criterion.
Thank you, Dr. Juan. No further questions, Judge.
Thank you. Thank you, Dr. Juan. You are, your testimony is completed and you may be excused.
Thank you.
I think we're on a roll, so if Mr. Lange is available. Do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Can you please spell your name for the court reporter?
It is Sean, S-H-A-W-N, Lange, L-A-N-G-E.
And Mr. Lange, you're another soft-spoken person, so I'm going to need you to speak up a little and speak
Sorry.
into that mic. Whenever you're ready, Mr. Pringle.
Thank you, Judge. Good evening, Mr. Lange.
Good evening.
By who are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as a senior professional engineer.
And Mr. Lange, did you contribute to staff's report in this case, which has been previously marked as Exhibit 109?
I did.
And did you also prepare for this case a rebuttal testimony that had been previously marked as Exhibit 104?
I did.
At this time, do you have any corrections to make to the staff report or your rebuttal testimony?
I have one correction to make to my testimony, and that is page 16, line 13. The sentence that starts on line 13. The way it reads currently is GBX is proposing that the power associated with the Mudgma contract travel the Tiger connector and be injected in the interconnection at or near McCready. I would like to change the word McCready to Burns. And so it would read, GBX is proposing that the power associated with the Mudgma contract travel the Tiger connector and be injected into the interconnection at or near Burns.
Are there any further corrections or additions to make to your testimony?
Not that I'm aware of.
If I ask the same questions today within your rebuttal testimony, would your answers be the same?
Yes,
And are those answers true and correct to the best of your knowledge and belief?
they are.
Thank you, Mr. Lange. At this time, I enter Exhibits 104 and 104HC into the record.
Would there be any objection to Exhibits 104 and 104HC? Hearing none, I will admit those exhibits.
Thank you, Judge. At this time, I tender the witness for cross-examination.
I'm going to ask General, is there going to be any cross-examination of Mr. Lange? None? Are there any commissioner questions for Mr. Lange? Mr. Chairman?
Good evening.
Good evening.
Did you review the testimony of Michael Milligan on behalf of the Sierra Club and basically his testimony on the benefits of the line to the RTOs and the regional power systems?
It has been a while since I reviewed his testimony.
We'll talk real 10,000 foot level. Do you agree with his testimony?
I guess, can you give me?
The general benefits he outlined of this project, for the region, for transmission, just the general summation of his entire analysis.
What I can say is that this project is very complicated, and that the benefits associated with this project can be challenging to discern, partly because the end users aren't kind of known. So where that power and where those potential power attributes may go may not be readily known. The project can provide and has the ability to provide, reliability benefits. It is an additional transmission resource. It can help provide power to the region. It can, it's acts as another transmission resource. The challenge is where and to what degree the benefits will be, if you will. I'm not trying to say that there will not be benefits. I'm just trying to say that how to calculate those and to what RTO or where those benefits may manifest themselves is not readily discernible. I don't know if that
I
really...
think that's fair enough. Your testimony kind of hinged on the revenues generated through the cost of energy through PJM, for at least from my recollection of it, and that was like a key deciding point, that if those revenues are not there, the $10 differential that was brought up in the last case, that kind of negated a lot of the potential value or revenue for this project. And therefore, the phasing should not be gone ahead with. Am I summarizing that correctly in your opinion of what you are trying to convey in your testimony?
I think you may be summarizing Mr. Stallman's testimony.
Oh, crap. I am. Because she said Stallman was going to be our last, and
Yeah.
Everybody wants Stallman.
That's right. That's right. All right, well. Everything else going well for you?
Yeah.
Excellent. Well, that's all I had for this one.
Okay. Are there any other commission questions for Mr. Lange? No. Okay, I have one here on my paper. Let's see if it's still relevant. In Baker's rebuttal on pages 8 to 10, he responds to some concerns you raised in your rebuttal related to the Guidehouse report. Did his response address your concerns?
If I may, Judge, may I drop a?
Yes.
Mr. Thank you.
Yes, thank you.
Mr. Baker's sir rebuttal, I will be bringing to the witness.
And it starts at page 8.
Through page 10, is that correct?
Pages 8 to 10, he responded to your rebuttal testimony, and I just wondered if his response was to address your concerns, or if you still have remaining concerns, what they are.
Well, I think this kind of goes along with my answer to Mr. Chairman's question, that with the amount of information that is known at this time, it is difficult to discern where and necessarily when and how the benefits will manifest themselves. So, in as much as the Guidehouse report and what I have seen of the Guidehouse report assumes what I would view as kind of best case scenario, and the benefits of that best case scenario, you know, what those would be and where those would manifest. I can't necessarily say that that will happen. And I think that that goes to a lot of the issues that staff is having, you know, with the Guidehouse study itself.
Okay, thank you. Anything else? Will there be any further cross-examination questions based on questions from the bench?
I do have a couple.
Okay, anyone else? All right, go right ahead, Mr. Schulte.
Picking up where the judge just left off, by best case scenario, are you referring to a scenario where relevant commercial agreements are executed for offtake of the capacity and energy from Grainbelt?
When I said best case scenario, it is that the power and the capacity from the line would be contracted for in such a way as and I don't want to get into any of the HCC information, but it is assuming that the capacity of the line is contracted for. It is assuming that the energy over the line has a certain level of capacity factor, and it is assuming that, you know, those assumptions, like I said before, with the relative information that we currently have, I find it difficult to make those assumptions fact that this will happen in this way. It could, but to say that it will, I don't know if I could say that.
Okay, I heard you list the best case scenario includes commercial contracts are executed for capacity on the line, and that the capacity factor of the energy delivered is as Grainbelt has said it will be. Are
In
those the two?
studies.
Are those the two?
I believe so.
And hypothetically, because I understand that you have some concerns with those two assumptions, but assuming for the purpose of this question that those two factors are fulfilled, do you have other issues with the Guidehouse report's methodology?
When you say fulfilled,
If those two factors are satisfied in your referenced best case scenario, do you have issues with the Guidehouse methodology? Or is it just those assumptions?
well, I was speaking in response to the rebuttal testimony of Robert Baker, as far as the overall Guidehouse report. I think staff witness Claire Eubanks is the person to ask about other issues that staff may have with that study.
So on pages 9 and 10 of Mr. Baker's Sir rebuttal testimony, line 10, are you there? Do you have that document?
Line,
Page 9, line 10.
page 9, line 10.
Mr. Lange states that the assumptions made by Guidehouse overstate known impacts on capacity auction prices because current contracts do not interconnect into MISO. Those current contracts are what we've been talking about, right, with regard to contracts for delivery of energy over the Grainbelt Express project?
I would assume that is what he is saying.
And Mr. Baker goes on to testify, I would like to reiterate that the Guidehouse report utilizes several future state assumptions, including the presumption that relevant commercial agreements are executed. And so my question is simply, is your issue with the Guidehouse study those assumptions, or is it the underlying methodology?
I would have to say my issues or any issues that I have outlined with regard to the guidehouse study would have to be with regard to the assumptions made.
Okay, thank you. I think I do have one more subject. Chairman Roop asked you some questions about the reliability and resiliency benefits,
Yes.
and your response was that the benefits are difficult to determine because we don't know the specific contracting off-takers for the line. Is that a fair summation?
Yeah, I would say that's fair.
Would you agree that the reliability and resiliency benefits depend in large part on the capacity of the transmission line, the capacity and engineering capabilities of the converter stations, and the locations of the various points of interconnections and those converter stations, rather than the specific identity of contracting off-takers?
Well, the contracting off-takers would show where those benefits would be with regard to the RTO environment. So, I mean, yes, and I think this goes to other staff issues or issues, is that there is a difference between capability and what would realistically, or I won't say realistically, what is feasible. So yes, there is capability on the line, but what is the feasible manifestation of the power attributes, and where is that going to occur? And that's where I have difficulty.
Sure. So the economic feasibility of the project is tied to the commercial contracts, right? And the identity of commercial partners. But
Yes.
I'm not asking about that. I'm asking about simply the reliability and resiliency benefits are a function of the engineering capabilities of the line, are they not?
They would be a large part of that would be the engineering capabilities of the line. But then who has control over that line, as far as what RTO may have dispatch authority over that line, will, at least in my mind, play a role in that.
Okay. I have no further questions. Thank you.
Thank you. Is there any redirect from staff?
Yes, Judge. Mr. Lange, regarding the guidehouse study,
Yes.
again, other than the size of the line, did that study consider any other engineering designs?
Engineering designs. Not that I'm aware of.
And then there was a lot of talk about the executed contracts. But what about generators as a source of power? Do you have any questions about that in your analysis?
And Yes, part of that is, that goes to the, I know other witnesses have had this question raised, the capacity factor, and what,
I'm sorry, I have to object. I don't want to, but I don't want to lose an opportunity to cross-examine a witness on a new subject matter. This did not, the capacity factor and the identity of the generators on the western terminus of the line did not come up in any of the bench questions or cross-examination.
Yeah, response, Judge, a lot of the talk was about unknowns on the line. This is another unknown.
I'm gonna let him answer, and Mr. Schulte, since I gave Mr. Hayden a little extra cross-exam earlier, I'll give you a second shot as well if you feel the need to respond.
Knew I should have objected to that at the time.
You may answer, Mr. Lange.
would you mind repeating the question? I'm sorry.
Yes, it had to do with the unknowns regarding the generators for the line.
Oh, yes. I think in the guidehouse study, there has been assumed level of capacity factor, and that would make certain assumptions as to what the mix of wind and or solar and or potentially storage may be. But as far as, I am aware, I do not know exactly what the mix of generator resources will be. And that capacity factor is vastly different if it is mainly wind versus wind and solar versus wind, solar, and storage, or it could be.
Thanks, Mr. Lange. No further questions on this redirect.
Thank you. Mr. Schulte, did that raise any questions for you?
I think I can reserve my questions for Mr. Stallman.
Okay, thank you. In that case, Mr. Lange, your testimony is complete, and you may be excused.
Thank you.
Okay, so it is almost 7 o'clock, so we're gonna wind down. But I want to find out first if there's going to be any cross-examination of staff's next witness. And I'm not, is it Pudel? Is that how she pronounces it?
Yeah, Dr. Krishna Pudel.
Okay, thank you. Are any of the parties gonna have cross-examination for that witness?
Greenbelt does not.
Okay. Okay, I don't think the commission has any questions for that witness as well. Would you like to go ahead and offer that testimony?
I would love to.
If
that's okay?
Yeah, we may be able to do this for a couple other staff witnesses.
Okay.
At least from Greenbelt's perspective, obviously the bench has their opportunity as well, and the parties. But from Greenbelt's perspective, we don't have any prepared cross of Alan Bax, Jordan Hole, or Michael Rush of the remaining staff witnesses. Of course, if the commission has questions, we would reserve our right to cross-examine on
Absolutely.
bench questions.
As far as Alan Bax, do any of the other parties have cross-examination questions for Alan Bax? For Jordan Hull? And Michael Rush? Okay. I haven't had an opportunity to check with all of the commissioners about Mr. Rush and Mr. Bax. You didn't think you had any for facts? Okay, I'm gonna, let's go ahead with with Pudell and Hull, because I don't think there's any questions for those two. There might be some commission questions for Bax and Rush. So let's go ahead and dispose of the testimony for those two staff witnesses and then call it a night and then come back with Mr. Bax in the morning. And we may quickly dispense with those two staff witnesses.
That works for me. Yeah, so we're just going with Mr. Hall and Dr. Padel. They're the two we're just going to enter in their testimony, correct?
Yes.
All right.
And if you just, unless are there corrections for any of that testimony?
Not that I'm aware. Let me just double check. No corrections for either one.
Okay, if you just want to offer those,
At this time, I move to enter staff exhibit 103 and staff exhibit 105 into the record.
would there be any objection to exhibit 103, which is the rebuttal testimony of Jordan Hull, or 105, the rebuttal testimony of Krishna Pudell? Seeing,
Judge,
yes.
can we have Dr. Padel stand up and wave? He has been eagerly waiting all day to testify and to get to the point, and now he's like, oh. So just stand up and wave.
Very good. Okay, with that, I will enter those into the record. And we will start tomorrow again at 8:30. And if we can be as productive as we were today, we can maybe finish, even if we have to stay a little late tomorrow night.
And just so we're clear, Judge, we'll be starting tomorrow morning with Mr. Alan Bax.
Yes. And are there any other, before you take off, everybody stay seated. Are there any other preliminaries from the parties? Okay, or anything. Commissioner would like to have the mic.
Yeah, thank you. I just want to let everybody know that tomorrow I will have to go back to Kansas City. I've got a 2-month-long wait with a cardiologist to see. And if I don't make it, it might be another 2 months. And I would appreciate some grace here and let me do that. I will be calling in from the WebEx. So I will be participating, and I do have some questions for tomorrow's witnesses. So you will hear me over the loudspeaker, but I just wanted to let you all know why I won't be here in person. Thank you.
Okay. Okay, on that note, now you can run out of here. We can go off the record. And I apologize, I thought of one other thing that I didn't tell you all, is that the elevator in the parking garage stops at 6 o'clock.